mention. Criminal Appeal 503 of 19, that is before your Lordship and Justice Rao Pran. My Lord had adjourned it to 11th of November.
Is it part heard?
Yeah, bail matter, my Lord.
Oh,
Because your Lordship has heard.
Right.
On 11th, it didn't function.
All right.
Now, today also it has not been listed. Next Friday, I'll not be available. Can it be some other day, my Lord, next week?
1 o'clock. Maybe on Wednesday. Wednesday, 1 o'clock.
I'll send the members.
It won't take long, the matter?
No, it
All
won't take long.
All right.
Copy of the.
Yeah. Copy of the bail application he wants.
That is already on record. It has been served on them long.
It's not a fresh one. It's an existing one. Yeah. Online.
Of the list.
Oh, there's no online mention. No. All right.
Supplementary list for orders, item number 1.
Wait, please, Lord. This is an
Lord, we are led by Mr. Senior Advocate C.S. Vaidyanathan this matter. Perhaps.
Wait.
Yes,
Wait,
yes.
wait.
Yes, Mr. Yes.
Yes. This is an application where my Lord had passed an order on 12th January. The writ petition challenges the order dated 22nd December 2020, where my Lord had revoked the letter of intent which had been issued in my favor has been revoked. And Miller, forfeiture has been ordered of upfront payment of 90 crores plus the bank guarantee of 90 crores 60 lakhs. Now, Miller, we had challenged it. My Lord said entertained the writ petition, issued notice. Now, Miller, my client, after this 2-year period, Miller, is of the view that Orissa Mining Corporation has extensively mined the area and it doesn't make sense for him to now take the mine. Therefore, Miller, he would like to confine the relief in the writ petition only to seeking return of the money which has been forfeited rather than pressing for letter of intent for the mine. Miller, therefore, this is a matter, I'll be able to demonstrate that we have complied with all the requirements which were insisted upon before the date.
Mr. Vaidyanathan, if you're now confining your relief to one particular prayer,
yes, sir.
Is it not appropriate that you file an affidavit or an amendment to your prayer, or how do we take that on record?
In our application, we have said so, Miller. In the very application, we have said we have confined ourselves.
No, this application is 12931.
Yes,
This
sir.
only seeks a modification of the interim order.
That's right. Now, Miller, the reason is, Miller, there are two things. Miller, one is, if the order of will have to be set aside, though Miller, I am not seeking revival of the letter of intent because this order has to be set aside to the extent that the forfeiture has taken place and consequently Miller, there is a disqualification which now Miller, as a consequence of this, now Miller, I am barred from making any bids. Therefore, that will survive. Therefore, this order will have to be set aside. Miller, the writ petition prayer is for setting aside the order that will still continue, except that I may not ask for revival of the letter of intent.
Can we do one thing? Then we'll issue notice in this application.
Very well.
Let the Advocate General come back.
Milord, I appear for the state, Milords.
Yes.
I am offline. Can your Lordship hear me, Milords?
Yes, yes, of course.
Yes. Milord, to pray.
I think.
We are for the opinion number 2 only, man.
Was not compliant. He was not compliant. Now, so far as the mining is concerned, Milord, fair to Vaidyanathan that
Mr. Parija, you're not very clear. The connection is not very good.
Milord, I was only requesting if your Lordships call it after a week, we'll put in a short affidavit. Your Lordship may issue notice.
All right, all right.
Yes.
All right. In fact, I think I'll ask it to be, yes. All right. You say notice, Mr. Parija accepts, Mr. Mohanty accepts notice on behalf of the state and Mr. Padi on behalf of the other respondents.
OP3, my Lord.
All right.
I appear for OP3.
OP3 is Mr. Mudali. Then you say Mr. Parija states that he will file a short affidavit. You say right at the beginning, you say Mr. C.S. Vaidyanathan, senior advocate for the petitioner applicant, states that the petitioner would like to confine the prayer in the main writ petition itself to return of the forfeited amount. Full stop. He states that nevertheless, for that to happen, the petitioner will still insist on the impugned order dated 22nd December 2020 being set aside.
Yes.
Paragraph Mr. Parija states that he would like to respond to this application by filing a short affidavit within a week's time. Next Friday is going to be difficult, so we'll have it on the Friday following,
Very
2nd December. 2nd December. All right.
Grateful.
All right. All right.
Item number 2.
Please, my lords, I am led by Abhishek Rastogi in this matter.
May I please, my lord?
Yes.
My lord, while there is an interim order, my lord, in my favor, respondent number 2 has filed the counter, my lord. Respondent number 1 has not filed the counter, my lord. So, my lord, if they submit that, they would go ahead with the common counter, my lord. We have no difficulty. We'll within a week file a rejoinder, my lord. It can be kept, my lord, 1st or 2nd of December, my lord.
All right. But who can make that statement? Only counsel appearing for. Mr. Padi, are you there?
It is a text matter.
He's from
No, no.
respondent one.
You are for respondent number 1, sir.
Union of India is respondent one.
The Customs Department has filed a reply. So will the Union of India adopt that?
Then I have to take instruction, my lord. I don't have that instruction.
You say
I'm not
while
receiving
respondent
any
number
response
2
from
has
them.
filed a reply.
Several communications, man.
All right, Mr. Padi Leonard, DSGI, appearing for the Union of India, states that he will have to seek instructions on whether he would like to adopt the counter affidavit for respondent number 1 as well. Paragraph. In any event, a last opportunity is granted to respondent number 1 to file its reply within 4 weeks.
Obliged, ma'am.
Rejoinder
Lord,
before the
order
next.
dated 15th Feb may continue, my lord.
Yeah.
Yeah, interim. There is an interim order, right?
My lord, there is an interim order dated 15th of February 2022, my lord.
All right, the interim order to continue. This does not have to be on a Friday. I think it can be on any day.
My lord, if a fixed day is given, my lord, that will be better, Lord, because we'll be coming from Bombay, my lord. If it is virtual, my lord, then it should not be a big problem.
That's right. That's it. So 24th January.
24th
Obliged,
January.
man.
All right.
Obliged, man.
My lord,
Item
can
number
we-
3.
my lord, instead of 24th January, my lord, can we have it 25th of January, my lord?
25th. All right. 25th.
25th
25th January.
Obliged.
Item number 3, sir.
My lord, on behalf of Mr. Rai, he has gone for his medical checkup. So it can it be in any day next week, my lord?
Mr. Rai, for the petitioner stated to be in some personal difficulty today. Is there a reply to be filed? Mr. Chimanka,
I think they have already filed their counter.
they have?
Yes.
All right.
I have already intimated Mr. Chimanga also.
You don't wish to file a rejoinder, right? No. You don't wish to file any rejoinder, do you?
So I have to take instruction from. Mr.
All right.
Rai.
Rejoinder if any be filed for the next date, interim order to continue. List on 25th January.
Item number 4.
May I please use this? This is a matter relating to the 148 provisions, madam. There are 3 notices issued on 148. 2 notices on 31st March 2021 and 1 notice 142021. Had it been 142021, basing on which the assessment order has been made by the assessing officer, it has to follow the new provisions. That is basing on Ashish Agarwal's case.
Correct.
So if it is old provision, the department has no case. Department itself agree, it is 142021. It is mentioned in the order itself as page 24 minor.
No, what do they say in the counter? Which of the 2 are they adopting?
In their counter, my lord. Paragraph 9, my lord. Paragraph 9, page. Paragraph 9. that the aberrations made in paragraph 9 of the writ application, it is humbly submitted that the notice.
No,
under
no. So
section-
they are abandoning the 31(3) notice. They themselves said since it was not delivered to you, they've decided to issue a fresh.
Notice on 1/4/2021. So 1/4/2021, basically means they have acted in their assessment order. Had it been 1/4/2021, then it should follow.
There is confusion in this para 9.
Lordship, kindly have a glance, Annexure 3, running page 14, the notice itself, Lord.
Yes.
Your Lordship, see that 31(3) and the bottom line, your Lordship, see that a digital signature was issued, my lord. You
No,
didn't
no, you
type.
be clear. You be clear. If you're going by when was this notice delivered to him, since it
Yes.
was never delivered,
Correct.
you are actually abandoning this notice, correct?
But the notice itself in the 31(3) is a continuation of the next page. Your Lordship, see Annexure 4, running page 15.
No, but that becomes the 1/4 notice.
Correct, no.
Then that you can't go back to 31(3).
Your Lordship, that give the liberty so that we can proceed so far as 148A proceeding. Because
Then
in
we
this
from-
case, my lord, assessment order has already passed.
Yeah,
Your
you say from para 9 of the counter affidavit filed by the department, it is plain that they have decided not to proceed with the earlier notice dated 31st March 2021 issued to the petitioner under section 148 of the Income Tax Act 1961 for the assessment year bracket AY 2016-17. Paragraph. The department has taken a stand that it is now proceeding only with the subsequent notice dated 1st April 2021, in which event it will have to follow the new regime put in place by virtue of the amendments to the act with effect from that date. Full stop. Then you issue a fresh notice under 148A 1B.
Correct.
My lord.
Your Lordship, here, let's say.
It is therefore clearly understood that the department will now proceed only by issuing a notice under section 148 capital A bracket 1 bracket small b
My lord.
of the act. And till such time that entire procedure is completed, no coercive action will be taken against the petitioner.
So far as the assessment of pass in this,
Obviously, you say consequently the assessment order
Annexure 7.
dated
Annexure 7, running page 20.
30th March 2022, which was passed pursuant to the earlier notice dated 31st March 2021, will no longer be valid and is hereby set aside.
Then no coercion is required. Because the
All right.
order is the order is.
All right. The petition is disposed of in the above terms. All right. Much obliged.
Item number 5.
Item number 5, December, where I had taken out notice pursuant to order dated 20th of October 2022, and the interim orders were passed in my favor. Now,
You have not filed a reply.
no, my lord, if they would
My
like to
lord.
file a reply,
My lord,
What has
we have
happened?
entered appearance for OSBC, Odisha State Beverages Corporation on 14/11. We need 2 weeks time to file our contract.
All right. Time is
My
sought
lord,
both on behalf of the.
May I submit one thing to?
Yes, please. Yes.
132 writ applications were filed. Those were remanded to the secretary and a common order has been passed shortly. And one of such order is impugned in this writ petition. That is relating to exemption of FJQ during the COVID period. I will only draw your lordship's attention to page 34 of the writ petition. What are the reliefs granted by the secretary, whether it is again open for the vendors to approach the honorable court. Page 34, internal page 23. Page
Yes.
34 of the writ petition.
Yes.
Whereas as plus clause 4D of the excise policy and so a committee has been constituted by the order number within the following members, so and so. And the committee will recommend the genuine matters to the excise commissioner Odisha Cuttack to redress the MGQ related grievance, if any, and excise commissioner Odisha Cuttack may waive up to 10% of the MGQ on genuine grounds on recommendations of the committee. Hence, in case they continue to face the genuine difficulty in meeting MGQ commitment, even after availing all the above concessions, it is open for them to approach the excise commissioner or redressal of their grievance. Since on closer scrutiny of the entire matter, it reveals that the representations were submitted before the expiry of the extended period of fulfilling the MGQ commitment, 30th also, due to massive inflow of similar orders in as much as representation thereof, the government in excise department has already taken a feasible decision proactively by this department.
No, so this is only now pushing it all to the committee.
Yes,
Ah,
that is what
They
I'm saying.
themselves not taking a
So,
decision.
not only the client of Mr. Ratha, there are so many petitioners. 132 petitions were disposed of, and the government was directed to dispose of the review. This is the, if your lordship feels that despite this accommodation or this arrangement, still interference of the honorable court is solicited or
This is the impugned order. correct?
yes, this is the impugned order.
Yes, Mr. Ratha.
My lord, it requires an interference from your lordship, my lord. The reason being, these orders, license-wise, my grievances before your lordship, before the government was that, despite the state, my lord, apart from the statewide closures, this close down notifications, after they were lifted, the district administrations weekly shut down and close down of those shops continued for a considerable period. Those period pursuant to the district administration orders, shop remained closed, and that very specific plea we have taken in our representation. The government has not dealt with that. Government passed a common order for without dealing with our specific grievances.
No. All that the government says is we've now constituted a committee. Why don't you go with the committee?
The committee can't. Committee, your lordship, see, they have limited the committee's power to 10%.
No.
That's not the issue here. We are
No,
entitled to kindly, Mr. Manthi, kindly start my representation 112 months.
So you say since the jurisdiction of this committee
Yes.
should not go beyond 10%.
Kindly, my lord. Yes, grateful, my lord. That's the point. He should come back.
Why have you limited it to 10%?
My lord, your lordship may kindly have a glance. Hence, in case they continue to face genuine difficulty in meeting MGQ commitment,
No, the line above that.
it is open for them to approach the Excise Commissioner of Odisha for redressal of their grievances. So after that, Excise Commissioner is also there to.
No, but you limited, just read the line
Yes.
before that.
Before that, yes.
The committee will recommend.
May waive up to 10%. This is the standard of waiver government has fixed. Beyond that, they may approach the Excise Commissioner, and if it is.
No. That line includes the Excise Commissioner also.
Yes.
Redress the MGQ related grievance, if any, and the Excise Commissioner may waive up to 10%.
Up to 10%.
Right.
Then beyond that, if there is some genuine case and anything that the wording is appropriate cases, then Excise Commissioner may exercise its power, and that is the order. If your lordship will say, I will file counter affidavit. Nothing.
No. If you can make a statement.
Because there
That
are a
will
lot
not
of
be
cases.
limited to 10%, to be on a case by case basis.
Case by case basis, subject to adjudication by the Excise Commission.
No, then it should not be limited to 10%.
Yes.
Suppose in a given case, it's found that waiver up to even 80% is justified because of the circumstances. Then the Excise Commissioner should not get limited by this circular to say my powers are not only to excuse up to 10%.
10% is given by the government. Thereafter, case to case, the commissioner has to take.
There's no clarity on that. An Excise Commissioner reading the circular might think his powers are limited to just waiving 10%.
Your lordship may again read this.
Yes.
And the committee will recommend first they will approach the committee. Committee
Right.
will be constituted, they will approach.
Right.
Matter to the Excise Commissioner Odisha, Cuttack, your lordship may see that Excise Commissioner is not a party to this committee.
No.
He is not a party.
The committee is a recommendatory body. Its recommendation will go to the commissioner.
Yes, if any, and Excise Commissioner may waive up to 10% of the MGQ on genuine grounds or on recommendation of the committee. Full stop. Hence, in case they continue to face genuine difficulty in meeting MGQ committee, even after availing all the above concessions means 10%. It is open for them to approach the Excise Commissioner for independently. That means independently they will approach the Excise Commissioner, Cuttack, for redressal of their grievance. This is the
Lordship, may kindly
order.
see the state's notification. Kindly see. Well, Alfred is saying which is completely beyond their own notification, 115.
115.
Yes, ma'am. This is a government's notification. Kindly see page 116 exactly at para 4. This is the notification on the basis of which that order has been passed. Now, this notification of the government para 4 excise policy has a provision for setting up a committee under Excise Commissioner to look into genuine MGQ related grievances of the license. Excise Commissioner could relax up to 10% of MGQ on recommendation of the committee. Therefore, after availing various relaxations provided by the government, if any licensee has still any genuine grievance.
So I think this entire paragraph has been repeated.
That's right.
This has been
Lord.
copied. This has been, I think this has been borrowed.
Yeah.
From
That's
this
right,
policy.
Lord. Now, your Lordship may kindly see the maximum power is given to the Excise Commissioner is 10%.
No. I think the second line,
Yes.
what he says, there is something in what he says.
That's correct, but it's the power of the government. Now your lordship, your district wise close down and shut down notifications varies from one district to other.
That is why commissioner
Once-
is.
Mr. Mahanti, please allow me to complete my sentence. Your district wise notifications close down and shut down varies from one district to other. Collectors, depending on their circumstances, they used to issue notifications, weekly shutdown, in which week it will be closed or not. So all those notifications are different from one district to other. Your lordship relegated me to the government. Now government should receive the notification passed by the
No,
government.
suppose we clarify that this circular does not limit the power of the commissioner
Yes.
to only 10%.
Yes.
Because the way we read it is one part is up to 10% go to before a committee, and the committee's recommendation, the commissioner will
Yes.
waive.
Yes.
If you still think it
Yes.
should be beyond 10%.
Yes. Yes.
Then you still have, you can go to the excise commissioner.
Correct. That is what
I don't mind going excise to the excise commissioner. But then they should, I have taken a specific plea. Now the government has not considered that because all are notifications by the government. Government should consider that whether the district administration closed or not closed. Now again, one round of litigation, again going to the commissioner when the order is before a lordship. My lord. We seek only that period.
No, there is no order of adjudication by the commissioner on your request.
Yeah, we were on their submission, we were relegated back to the government. Now government definitely is superior to the commissioner. Now they are relying upon this notification. Let the government take a call on the basis of their own order. They have passed it.
But tell me one thing, you were only multiplying cases.
That is-
Yes.
No, because everybody is not going to limit their waiver of MGQ request to
Yes.
just 10%. Most of them will say, waive the entire MGQ because of COVID. We couldn't
My
operate our
lord,
shops.
nobody knows it. My lord, claims clients, they are interested for this. They let them apply, and commissioner will examine case to case basis.
But if you are setting up a committee, why are you limiting it to 10%?
That is the excise policy. We cannot go beyond that. This
No,
second,
that is your own policy.
Yes.
that is what, but policy has to be changed. Your lordship,
That's
that
right.
is-
That's right.
Policy cannot be changed like this. That is why the government has given the power to the excise commissioner to examine the representation case to case basis. If something is found to be genuine, some cases, if my non-friend's clients is found to be genuine, because it is all collectors, all districts are not similar. Where the collector Jharsuguda is doing, where not the collector Balangir. So the case to case basis, he will examine. So, and if you,
Lord, it will be
and
rather-
so far as the remand is concerned,
Step process, go before a committee and then go to the commissioner.
Another
It's
round of-
actually making the commissioner's exercise easier because the committee has already examined it, made its recommendation. Why should that committee not look into all the claims? Why should it be only up to
committee's-
10%?
My lord, committee's jurisdiction is 10% according to the excise
No,
policy.
it should be see, the committee is a recommendatory body.
Yes, ma'am.
Why should its recommendation be limited to this 10%?
Because that is the policy of. the
No,
state.
that's the whole question. That's why he's
Then,
before the
then,
court.
then if your lordship will say that whether we can change the policy at
Correct,
least,
not limited to just 10% waiver, because anyway, it's not that as if
then why I am submitting this respectfully?
Mr.
My
Mahanti,
respectful submission is that.
Rather will court sort the litigation.
No, my
Once they
respectful,
take that
no,
decision,
it will not court. My respectful submission is that committee is as a whole, it will recommend up to 10%. Not that all the vendors are agreed by the committee's decision. Some may accept it.
correct.
If somebody is saying that,
But no vendor is going to be satisfied with only 10% waiver of MGQ, right?
how can we say, sir?
Anyway,
Somebody may say that I am ready to accept this and.
It's only realistic to expect that. No,
No,
if somebody says waive the MGQ.
that is why we have taken the decision that beyond 10%, if somebody is.
No, if you are permitting beyond 10% to go to the commissioner, you might well ask the committee to look into the entire thing.
that
If you
is-
are not permitting, suppose you
that
said
is,
as a
In
policy,
that event, we have to amend the policy.
correct. Because if you took a policy decision that you will never allow a waiver beyond 10%, then we examine the reasonableness of that policy.
My lord, excise policy yearly, we are, now the people, officers are going through that year, they will release the excise policy. But if your lordship will interfere with this, then I have to file a counter affidavit. That is my resolution.
No, that anyway, I think we should notice already. So,
Yes.
no, why don't you come back specific to this? You say the challenge resolution is to the order dated 13 March 2021 issued by the Excise Department on the question of waiver of minimum guaranteed quantity, bracket MGQ, which the licensees are obliged to fulfill. Full stop. On account of the COVID-19 pandemic, the difficulties were faced by the licensees in meeting the above requirement. And this led to a whole spate of litigation. Full stop. In the first round, the government undertook to formulate a policy. And therefore, those writ petitions were disposed of in light of the said submission of the government. Full stop. The impugned order sets out the policy government in this regard. Full stop. What is immediately relevant is clause 4 of the policy, page 116, which reads as under paragraph. The grievance of the petitioners is that the committee that has been set up to make a recommendation to the commissioner is constrained to recommend relaxation of MGQ only up to 10% and not beyond. Full stop. In response, Mr. D.K. Mohanty, learned additional government advocate, points to the second sentence in the above paragraph, which permits a licensee, if still aggrieved by the decision of the commissioner on the recommendation of the committee, to approach the commissioner himself for further relief. Paragraph. The question that arises is whether the committee can examine all the grievances at the first stage and make its recommendations on waiver of MGQ not limited to 10%. Full stop. Mr. Mohanty states that the response of the government on this specific aspect will be placed before the court in the form of an affidavit.
Obliged.
Within 4 weeks. Full stop. It is open to the opposite party number 5 to also file its response within the same time. Rejoinder thereto, if any, be filed before the next date. February 1st.
My lord, there are so many cases of similar nature.
You give us the list.
Lord, I'm giving, they're all appearing.
In
in
all
the-
cases,
One second,
authorized.
Mr. Mohanty. Item number 6 and 7 will cover your lordship's order.
All
That
right.
6 and 7 additional point would be short supply. That will be covered.
That is covered.
That-
No,
Six-
other cases are there also.
1 second. 6 and 7 will cover your lordship's order. Lord, item number 8, this is a
Yes.
different set of litigation. From Jharsuguda, this matter was earlier before your lordship relegated it back to the government with a direction to deposit 50%. Now we deposited 50%, pursue the matter before the government. Now government has passed an order, but I am challenging that. Here also notices have been issued. I think they are supposed to highlight here. This is substantial points are involved here, I think.
Yeah, in 8, you say replies be filed within 4 weeks, rejoined before the next day. We need not have it on the same day then.
No, different dates maybe.
Different date. So this can be 21st February.
Yes.
This item 8 can be 21st February. You say counter within 4 weeks, rejoined for the next week.
Lord, all these 5, 6, 7 and 8 interim orders to continue, my lord. They are there.
There are interim orders.
There.
Yes, no course.
All right, interim orders to continue. All right.
Item number 9.
Your lordship, in item number 9, we have just received the counter today.
All right, rejoined if any be filed for the next date.
Your lordship, there is an IA in the writ petition, wherein I am praying that a direction may be issued to district excise office to open the premises so that they can take the inventory list of the stocks and they can shift it to warehouse so that
What do
I
you
can
say
use
to
the
this?
premises.
Let them take a,
Item 9, I am filing the counter affidavit. I just wanted to solve it to Mr. Ponda and
he seems to have a copy anyway. He says, why don't you allow him to remove the.
No, then it tantamounts to allowing the writ petition.
No, your lordship, in that premises, we have furnitures and
We have,
everything. We need to maintain.
we
that.
have cancelled the license.
Correct, but he wants to remove his furniture and other stuff in the shop. Why can't he do that?
I think that is not the lookout of the excise department, that the law and order collector, because what has happened, this is a very sensitive case, your lordship must be knowing, that one son of a big journalist, he was found dead after he came back, and that is why hue and cry that is in media. And
This is an on shop.
Yes, on shop. We have.
So anyway, the shop is closed.
The license is cancelled, which is impugned.
Shop.
Okay.
And the shop is
So far as
closed.
premises is concerned,
Yes. It is his own premises,
no, he is let out by the tenant.
whatever, whatever.
Yes, well, whatever it may be.
But why can't you remove the furniture and other stuff?
I have to take instruction who has locked it because maybe the law and order authorities. Because-
But you are the state.
Yes, that is, but so.
Or
as-
you see in this
I reply, I will be given.
All
reply.
right, IA
Short
12077 of 2022. Counsel for the petitioner prays that the petitioner may be permitted to remove the furniture and other assets, movable assets in the shop, in the presence of the officers of the department, and a proper inventory be drawn up. And this can be without prejudice to the rights and contentions of the parties. Mr. Monty, learned AG, seeks time for instructions. We'll have it on a shorter date then,
Shorter date.
9th December.
Obliged.
Your lords,
All right.
oblige your lords.
My lord, your lordship may note that I have sought the copy of
Yeah,
the
yeah.
account.
Item number 10.
But here again, demand, they have filed a counter. Only they have sent me a copy of the counter. I have received a copy on 14th of November, my lord. But
All
they-
right. Rejoined if any be filed for the next date. There are interim orders here also.
they are also.
Interim orders to continue. 28th February.
Item number 11.
But it's a writ appeal arising out of consultation proceedings. In Lord, quickly I'll tell you also what's the dispute about. The learned
Before
single-
my learned senior begins, I may seek an pass over, my lord.
Today,
Today is a-
today is a special bench.
Yes.
Passover will be difficult, maybe some other day.
All right. Counsel for the respondent is stated to be in some difficulty today. In the interest of justice, list on 28th February.
20.
Oblige. Item number 12.
This matter, may I pray for some other date, or it will take
All
some
right.
time. Lords.
At the request of Mr. Kar, learned counsel for the appellate. Eighth March. Oh, sorry, 8th is a holidays. Sorry, I make a mistake all the time. 16th March.
16 months.
Right.
Sub item.
Yes, I bought it, obviously.
The interim order dated 13/4/2000.
In this appeal, there's an interim order to appeal. Oh, I see. Okay.
Give some
The interim order to continue. All right. All right.
There's no interim order in the first matter.
All right. In the second matter, you see.
Both over cases.
All right. We are done. All right. Second December.
Madam.
All right.
Item 1, I'm appealing for the.
Because I am for the,
Just now he has.
Item number
on me.
this is an application because the learned presiding arbitrator,
Hmm.
Honorable Justice DP Mahapatra
Hmm,
passed away.
that's
So,
right.
Lords, I am praying, Lords, your Lordship may direct any sole arbitrator under the aegis of the arbitration center, any retired judge, Lords.
Okay, not something, just now he served me. The matter will take care of some of the day, I'll take instruction from my clients.
You see, Justice DP Mahapatra is no more. Counsel for the respondents, opposite parties, seeks time for instructions. Second December?
Second, Lords, some difficulty, I'm not there.
Ninth?
Ninth, Lords.
All right.
Grateful.
Right.
Great.
Right.
Item number 2.
Item number 2, ARBP 57/2021.
You were to file the correct address of the opposite party. What happened?
Sir, on behalf of Mr. Suryakant Das Mahapatar, he is suffering from high fever.
No, but you have to comply with the previous direction. You have to ascertain the fresh address of the opposite party and file it in the registry. That you've not done.
Timing 12:30 PM.
Sorry,
Sir, 12:30 PM, 35 PM.
you're not audible, please. Can you speak louder?
Sir, 12:35 PM.
I'm not actually able to hear what she's saying.
Say after first week, after first week.
No, the previous order required you to ascertain the correct present address of the opposite party and give it to the registry within 4 weeks. This order was passed in September, 16th December.
Sorry.
You say the previous order has not yet been complied with. The last opportunity is granted to the petitioner to comply with the said order and furnish the correct address of the opposite party to the registry within 4 weeks from today.
The agreement.
That's still pending the Supreme Court?
Yes.
All right. It is stated that the issue is pending in the Supreme Court of India.
Your Lordship, my presence on behalf of the opposite party may be
All
required.
right. All right.
Much obliged.
3rd February.
Item number 4.
Please, my lord, I appear for the petitioner here. This
Yes.
is section 11(6) application.
Yes.
The arbitration agreement is not in dispute.
All right.
Now, my lord, the.
1 minute. Let me ask him, do you have any objection to the appointment of an arbitrator?
My lord, there is no dispute as such. There is a no claim certificate given on a notarized affidavit by him. And also the contract which was entered between the parties, it included the claims that there was a contract price, whole total price, which he had accepted. And on basis of that, he was chosen as the L1 for the work. The amount that he is claiming now is included in that contract price.
What do you say, Mr. Upadhyay?
In fact, that's what I wanted to say. First, my lord, see what has happened, what is the dispute about? During execution of, my lord, this contract, there was a revision of the minimum wages, my lord. Now, we raised a claim for revision of minimum wages that was receivable to us after we have shown the proof of payment. Now, they refused.
Mr. Upadhyay, I think your connection is not very good. Your voice is going off.
My lord, there is an echo or?
Now it's better. Now it's better. I think you need to stay closer to your device.
That's so what had happened was, my lord, that during execution of the contract, there was
Yes.
revision in the minimum wage, and that had gone up to 31% higher. So we made a claim that this has to be reimbursable once I show you the proof of payment. They refused it, saying no, this shall not amount to change of law. Now, when this matter was the execution of the work was completed, then we reiterated our claim. They are saying that, look, first you have to give a no dues certificate, only then we will issue you or disburse you.
No. So, Mr. Upadhyay, if you go back to the Bogaraf Polyfab decision.
Yes.
So you had to either soon after being compelled to give this kind of certificate, you had to either retract by another letter, or you have to lodge your protest saying that you're doing it under protest.
We did that. That's what I'm saying.
Where is the document which says that you did it under protest?
Now, kindly see, my lord, first, see, my lord, the format they have given at page 127, that you first give this notice certificate.
Correct. That all right.
Then kindly see, I've just seen 2-3 letters only. Then come to, this is at page 127.
Yes.
Then in fact, we wrote a letter on 8th August 2020. Kindly see, my lord, the 3 paragraph trading mail. It is to submit.
All right. Last line you say, in case of non-release, the NOC being submitted shall be treated as invalid.
Correct. Then,
all right.
Then kindly see, my lord, that then we give because they did not release our payment, so that we have to give an undertaking or say an affidavit we filed, which is at the page 130. Now kindly see the word of this. Say, second paragraph. We certified that the work under the above Amendment Act, including all amendments thereto, had been satisfactorily completed, that all charges or bills or labor or services performed or material furnished and other charges against the project, including those incurred by subcontractors, have been paid in full, and in accordance with the terms of the contract, that no lien on the attached against the property in the an improvement of honor, that no notice of intention to claim there is outstanding and no suits are pending by regions of work done on the project under the contract, and all the workmen's compensation claims have been settled.
No,
and
so the
there's
question, so the question is this, after this 7th August 2020 affidavit,
Yes.
did you write to them saying that you did this under protest or without prejudice to your other claims? Have you written to them after this?
Exactly the next date, my lord, page 129, 8th August,
Yes.
exactly the next date. The last sentence, if my lord sees, it is also submitted that in case of non-release of outstanding payments, this outstanding payments is mentioned in this affidavit itself. Last sentence of this affidavit says this this final bill dated 8/7/2020 is still pending. Except for that, there is a no due certificate.
I think let me finish. You will have your opportunity. Then kindly the last paragraph. We have submitted the last and final bill for settlement, and we declare that no further due is pending with OCPL against this contract. If any due is in whatever manner is found against the contract, we shall neither claim it nor raise any dispute in the unclaimed amount. So this was the given. This was pursuant to the other two letters by which they say, unless you give the no due certificate, we are not going to release your final bills. Then immediately, my lord, we wrote a letter that look, dispute has arisen because of the refusal. So we go for an amicable settlement. That is the condition precedent under clause 17 for arbitration agreements. So we went for an amicable settlement that did not.
No. So is it your case? 1 minute. Is it your case, Mr. Upadhyay, that after you submitted the affidavit,
yes,
they did not repayment?
Yes, that is the case.
Has been released.
And kindly see section 11(6)(a). This dispute had to be, even regarding this, has to be decided by the arbitrator. Once there is existence of arbitration agreement, this court will not go into the merit or demerit of the claim. The matter has to be referred to, and that they can raise this issue before the arbitrator. Can we say, my lord, section 11(6)(a) for a moment? It says the Supreme Court, or the as case may be the High Court, while considering any application under section 4, 5, or 6, shall not withstanding any judgment, decree, or order confined to the examination of the existence of an arbitration agreement. Now, existence of agreement is not dispute. Then, my lord, this issue has been decided not only in qualifier, but up to 2022. Supreme Court says this issue with respect to no claim certificate is very a doubtful thing, because sometimes we have no choice. It's like a no option choice, because unless we sign it, we can't get the payment. And therefore, even when they give the no claim certificate, we have a writing to them that look, we are doing it under duress. In our letter, say we are doing under. Can you see our letter first, my lord, at page 127 for a moment? We are saying the second paragraph. We once again request your good self for release of the pending payment immediately, since we are under huge financial duress and unable to clear the liability of vendors, wage payments of labor.
No. Where have you, after this 8th August?
Yes.
Did you write to them saying if not? No. When you invoked the arbitration clause, you wrote to them saying you've not made the payment.
In fact,
when did you? When is your letter invoking the arbitration clause?
I'm just first. Can you see thereafter there is a condition precedent before we revoke the arbitration, we have to go for amicable settlement. Right. There is a condition precedent. So can you see that letter is at page 137?
Right.
And then we are saying, we are asking for giving the details, the kindly resort to the amicable settlement so the matter could be decided. Then, my lord, request of arbitration, we immediately wrote to them that you will find, my lord, at page 140. 140, the request for arbitration. We have said that accordingly we hereby invoking arbitration.
I think let this be examined with the arbitrator.
My lord, just one paragraph from my counter affidavit.
All right.
I'll just rely on one paragraph. Page 8 of my counter affidavit.
All right.
The 6th line, my lords.
Yes.
In this regard, it is relevant to mention that the completion period as per the contract was 12 months. The NTP was issued on 8/1/2018, and accordingly the work started the same date. The completion period as per contract was 7/1/2019, but the work was completed on 36/20 after availing extension of time without any financial implications. further being fully aware of the scope of the work and the payments due to it.
This is the whole point. This is the whole point.
The
So
contractor never raised these bills.
No, your format itself compels him to give a no due certificate. You say without that, we will not release payment, correct?
My lord,
So whether this is done under duress, it gave him no option, all that let the arbitrate examine. All right.
He has further constructed.
This itself will be one of the issues in the arbitration.
Very last para of that page, my lord. It
Yes.
is further relevant to state that the contractor was further asked to construct a few units over and above the work mentioned in the contract.
All right.
The contractor has accepted the same and given consent in writing to execute the work as per the earlier awarded rate.
All right.
Without raising the issue related to increased minimum.
All right. All right. All right, Mr. Upadhyay, I am referring it. What is your claim? What is the extent of your claim?
I'm saying something. This is a tribunal of 3 arbitrators. In this case, 17.3.
If you both agree, then we can have a sole arbitrator. What is your claim?
Amount of claim. Yeah, I'll just show. I'll just see that on our application.
No, your notice invoking should have set out the claim.
Yes. I'll just give them out. 3.5 plus 4 crores. 3.5 of pending dues and 4 crores towards security. Around 7 crore.
So you can avoid the cost of arbitration going for a sole arbiter. Both of you can agree, my lords.
I think, my lord, that will be better.
Right.
Better. But
So venue of arbitration will be Bhubaneswar.
Bhubaneswar, my lords.
I see.
So it can be.
But I just, my lord, my instruction is, I don't know why, that there should be a tribunal.
No, it will only increase the cost and it becomes unwieldy.
In fact, my lord, that maybe in the Bhubaneswar and honorable retired judges of the High can be appointed.
Correct.
And we have already nominated one, so both of them can appoint the third one. This is the arbitration clause, and I cannot make off on a concession to this unless I take instruction.
No, you take instructions then. It might be easier then to have, unless you insist it should be a 3-member tribunal.
I will take just 5 minutes. Can we pass it over?
All right, we'll pass it over. All right, pass it over.
Item number 5.
Your lordship, may I please?
Yes.
This mediation proceeding is fixed on 20th 11/2022, your lordship. Mediation is going, your lordship.
Item 5, right?
Well, I am for the
Yes,
opposite party.
Yes.
The mediation date is fixed to 28/11, my lord.
All right. The mediation is in progress and the next date is stated to be 20th November.
Yes, my lord.
That is Sunday.
Yes, your lordship.
I see. So list on 9th
Not
December.
Sunday.
9th December. All right. All right.
Item number 6.
My lord, item number 6, my lord, I am appearing on behalf of opposite party, my lord. I see
Yes.
1 week time, my lord, for filing counter affidavit, my lord.
All right. Counsel for the opposite party seeks and is granted 2 weeks time to file a reply rejoinder before the next day. 16th December.
Item number 7. Item 7.
My lord, item 7, yesterday they served the copy of the reply and say, may I, sorry, my lord,
Item 7.
Yes, my lord. Item 7, I am for the Union of India, my lord.
Right.
Rasmi, like the extension of mandate. They have yesterday they have filed a copy of the counter reply to my counter. Number 1. Number 2, they
2 days,
against
2
the
days
order
before I have served. 2 days before I have served. This is 29A application.
Number 1.
Proceeding is
Number 2,
This is only for extension of time.
Yes.
there is a SLP is preferred against the order of my lord, and it was SLP number is 20893 of 2022.
I see.
Today I'm filing also memo. Diary number is such and such and SLP number such and such.
This is an SLP against the 23rd September order.
No. It is against the order of dated 22/7/2022.
Oh, I see. That earlier.
Yes, sir. So
Achha.
it is now they yesterday on 16th it was registered as SLP number.
Well, I appear for the
They
applicant.
filed a caveat in this respect. After they also know that SLP filed because
But I-
they filed a caveat with the Supreme Court, my lord.
1 minute. Mr. Datta, you filed a rejoinder also, is it? That's somehow not Yeah, it's
Yes,
not
yes.
come on record,
We have
and
filed
he's
a
filed an
rejoin-
SLP, he says, against the July order. Yeah.
I see.
He was just
But I am
giving us
not
the
aware
diary
of
number.
that. Anyway, when my
When
letter.
I am also SLP as
Well,
diary
when
number,
my-
I am providing to my senior, and they have also filed the caveat, my lord.
All right, all right, all right. It is stated by, you say the reply of the Union of India and the rejoinder there too. Oh, flag A and flag B are on record. Mr. Padi, learned DSGI, appearing for the Union of India, informs the court that a special petition has been filed at the Supreme Court of India against an earlier order dated 23rd July.
22nd July.
22nd July.
22nd July 2022, and is expected to be listed shortly. List on, we'll have it on 6th January.
My lord, may I pray one thing, my lord?
Yes.
There is a petition of my senior should I am consciously submitting my lord, that because the proceeding is going on and that next date is picked on 28th perhaps. So let it be status quo is continue till this next date.
No, but there's no extension of time. So where's the question of any interim order?
No, it is already mandate is completed. That's why I am telling. Already mandate has been.
No, my lord,
Let's fix it to some which date, my lord?
6th January. All right.
Your Lordship, in this case, I am filing the memo as my Lord Senior is copying. Copy, I'm sorry.
SLP and diary number, that's why I'm filing memo.
All right, all right.
Thank you.
Copy may be solved.
Yes, I'm
Yes, we will give it.
Just give him the copy. All right, all right.
I'm
Okay.
grateful. I'm
All
grateful.
right. Yes, Mr. Upadhyay. Yeah.
Item 4, we have section, my lord, may refer the matter to the sole.
All right, all right. We say in this petition, which is seeking the appointment of an arbitrator to adjudicate the disputes between the parties arising out of the e-tender agreement dated 20th May 2019. A reply is been filed by the opposite parties. Pointing out that an affidavit was submitted by the petitioner on 7th August 2020. In the form of open quotation, certificate of contract completion and no due claim, unquote, undertaking not any further disputes or claims. Full stop. Paragraph. However, Mr. Upadhyay, learned senior counsel appearing for the petitioner, points out that this was done under duress, and immediately thereafter, on the 8th August 2020, a letter was written by the petitioner to the opposite party, stating that if the on non-release of outstanding payments, the NOC submitted open quotation shall be treated as invalid, unquote, full stop. Paragraph. The question whether the petitioner had waived its further claims by virtue of the above NOC in the form of an affidavit appears to itself be an arbitrable dispute. Full stop. In the considered view of the court, this, apart from the claims and counterclaims of the parties, should also be examined by the arbitral tribunal. Paragraph. Although the agreement in question envisages a 3-member arbitral tribunal, both parties agree that this court can refer the disputes to a sole arbitrator. So there is Justice Pramod Patnaik, the former judge of the court. All right, all right. The court accordingly refers the disputes between the parties, including the claims and counterclaims, to be adjudicated by Justice Pramad Patnaik, a former judge of this court. The arbitration will take place under the aegis of the Arbitration Center of the High Court. A copy of this order will be sent to the learned arbitrator and the coordinate arbitration center forthwith. Yes, Mr.
Only
Upadhyay.
one claim and counter claim, if any, because so far there is no counter claim.
That's right. Counter claim, if any. All right. All right. Mr. Upadhyay, you should come and see the arbitration center here. It's very good.
This has been newly made.
Yes, yes.
In fact, Justice Lokur was talking about it that
I see.
not only the arbitration, because
Yes.
there is other things and like, transcript of something which was handwritten in Madras High Court and you brought it here.
I
Something
see.
like that.
Yeah.
Then
Yeah.
later.
All right. All right.
If my lord
This
could-
vacation I will come and see that, sir.
Yes, yes.
If my lord could mention that the contract price, my contention is that the contract price included.
All intentions are left open. So it's
All sentences are left open.
all right. All right.
I'm like,
All right. All right.
Specialist text admission item number 1.
May you please, Your Lordship, I am appearing on behalf of Mr. PK. So this matter has been infructuous.
All right. Counsel, the petitioner states the petition has been rendered infructuous.
My lord, in this same list, item also has been infructuous.
All right. 1 and 12. All right. Dismissed. All right.
Item number 2.
Permitted to raise all the points.
All right. Permitting the petitioner to raise all issues. Interim order secretary.
Item number 3.
Here, my lord, the only question is whether a complaint case can be directly filed with a prayer to, my lord, send it to my police for under 156(3). There is a judgment of the Honorable Apex Court, the Priyanka Srivastava. This is the only point to be decided, my lord. There's nothing else to be. Whether the complaint petition can be directly made to the magistrate with a prayer that 156 it may be sent without asking him to adjudicate that a complaint petition is filed. You give your initial
No,
statement.
but what has he done?
My lord, here, my lord, what has happened, my lord? There was the, my lord, 150. He has directly. Your lordship may see the petition, my lord. The complaint petition at page 16. The prayer starts. Lord. He directly prays in the prayer that it's therefore prayed that your honor may graciously please to send this complaint under section 156(3) of CRPC to the IIC Badgar PS with a direction to register the complaint petition under as an affair.
No. What has the court done on this?
My lord. Annexure 2, my lord. That is the order passed, my lord.
No, he has examined it. He's not mechanically referred it. He has examined it. He's done what he should be doing.
Now, he has to, my lord, record first, my lord. He has to record the initial statement. Thereafter, he has to, my lord.
What he has done.
My lord. What he has done, my lord, the page 21. The case record is put up today for passing orders of complaint petition filed by petitioner Lakshmi Narayan Mishra, represented through his counsel and other associates. The complaint of his case perused the complaint petition. On perusal of the same, it is found that the complaint has set into law motion in keeping with a view to take action against accused person such and such for commission of offence under section such and such. It is also forthcoming from the petition that complaint went to law.
So he has examined. He has examined the complaint petition.
No, the act says, my lord, he has to first record one initial statement, my lord.
Where is that?
My lord, section 200 of CRPC, my lord.
Who's with the complainant?
Complainant, my lord, he has not appeared, my lord.
No, has he been served? Lakshmi Narayan Mishra. Just see the service. Informant. Yeah, one Mr. L.N. Patnaik. All right, all right.
Somebody has appeared, my lord.
Right. So,
my lord, section 200.
Yes.
A magistrate taking cognizance of an offence on complaint shall examine upon the oath of the complainant and the witnesses present, if any, and substance of the examination shall be reduced to writing and shall be signed and by the complainant and the witnesses, and also by the magistrate, provided that when the complaint is made in writing, the magistrate need not examine the complaint and the witnesses if the public servant. Then section 202, my lord. Postmortem process of issue. Any magistrate on receipt of the complaint of an offence of which he is authorized to take cognizance or which has been made over to him under section 122, if he thinks fit, shall, in a case where the accused is residing at the place beyond the area which exercise his jurisdiction, postpone the issue of process against the accused and either inquire into the case himself or direct the investigation made by a police or by such other person he thinks fit, my lord. This is the point where he can send, my lord. It is the prerogative of the magistrate, not of the complaint, that you send it to 156.3. It is not the prerogative of the complaint. That is my whole point, my lord. It is the magistrate who has to decide whether it has to be sent to a police or he will inquire himself.
No. So it's to first
my lord,
examine the complainant on oath.
Yes, that he has not done, my lord.
What do you say, Mr. Manthi? It has to be sent back, let him record the complaint statement. You see, the challenge in the present petition is to an order dated 3rd August 2015, whereby the subdivisional judicial magistrate (SDJM) Bhubaneswar has, in ICC case number 1576 of 2015, passed an order referring the complaint filed by the opposite party number 2 to the police, to the IIC Badagada, yes, for registration and investigation of the case under section 156(3) CRPC. Paragraph. The challenge to the impugned order is on the basis that the SDJM failed to comply with the mandatory requirement of section 200(1) CRPC, which required him to examine the complainant on oath, as apart from the witnesses, if any, and reduce the substance of such examination to writing, which should then be signed by the complainant. Full stop. None of the exceptions to section 200, the proviso, the circumstances in the proviso to section 200, which dispenses with the examination of the complainant, do not apply in the present case. Full stop. It is only thereafter that the magistrate under section 202 has to take a call on whether to refer the complaint for further investigation by the police under section 156(3) CRPC. Paragraph. It may be here that despite service upon opposite party number 2 and earlier a counsel representing him, today none has appeared for respondent number 2. Paragraph. Having heard learned counsel for the petitioner and the counsel of the state, the court is of the view that the impugned order is unsustainable in law on account of the failure by the SDGM to comply with the mandatory requirement of section 200 CRPC. Paragraph. Consequently, the impugned order is set aside and the case is remanded to the file of the SDJM Bhubaneswar, and the case, that is ICC case number 1576 of 2015, is remanded to the file of the SDJM Bhubaneswar to be proceeded with from the stage of examination of the complainant by the SDJM on oath in accordance with section 200 CRPC. Full stop. The matter will now be listed before the SDJM Bhubaneswar for directions on 12th December 22. Copy of this order be sent to the said concerned court forthwith.
Much of it.
This is a peculiar case where the victim and his elder sister was stabbed. I have given a note, my lord. So kindly see the note, my lord. Victim and his elder sister was stabbed at their parental house by the accused husband. The petitioner number 1 is the brother and petitioner number 2 is the mother since death. The only bald allegation of the dowry at their matrimonial house. And the charge sheets already submitted under 498 and 302, 304, 307 and 406, 34 IPC. And section 4 of the DPI. where the petitioner number one has been as a prosecution witness number 20. The cognizance of the offence are already taken under 302 and 304, 307, 406, 34 IPC against the petitioner, which is perverse and no material. And hence the impugn order of cognizance to be quashed. My lord, I have given cited a decision of the Rupus Talwar case, clause B. Your lordship will kindly see the decision. Where cognizance of offence interference with the order only if it is perverse and based on no material. And the FIR copy I have typed for your lordship perusal and final for certified copy.
So all this can be tested only at the trials.
The charge sheet is there.
Yeah. This can be tested only at the trials.
Well, the cognizance be quashed and under 302 and 304, 307, 406 IPC.
Yes. You say, having heard learned counsel for the petitioner, the court is not inclined at this stage to interfere in the case, leaving it open to the petitioners to urge all the pleas raised in the present petition at the appropriate stage in the trial court.
Well, till that no course is needed.
The petition is disposed of. The interim order is vacated. The copy of this order be sent to the concerned criminal court forthwith.
My lord, what happened? Your lordship will dispose till he apply for bail, he will be arrested.
These are all cognizable offences. 302 and you can't have.
No, 302 and 307 is not made up against the petitioner.
All right. That the trial.
That is my case.
Correct.
There is no material and purpose, my lord.
All right.
Item number 5.
None appears dismissed.
Item number 6.
My lords, no instruction, my lords.
No instructions dismissed.
Item number 7.
None appears dismissed. Interim order vacated.
Item number 8.
Lords, no instructions.
No instructions dismissed. Interim order vacated.
Item number 9.
Permitted to withdraw, your lordship.
Permitted to withdraw. Dismisses withdraw. Interim order vacated.
Item number 10.
None appears dismissed. Interim order vacated.
Item number 11.
None appears dismissed. Interim order vacated.
Item number 13.
13. No instruction.
No instructions dismissed. Interim order vacated.
Item number 14.
None appears dismissed. Interim order vacated.
Item number 15.
Same order.
Item number 16.
Item 16 next week.
No. What is it for?
Passover, lords.
All right, Passover.
Item number 17.
None appears dismissed. Interim order vacated.
Item number 18.
Same order.
Item number 19.
I think by liberty to take all.
Yes, permitting the petitioner to raise all pleas. The interim order is vacated.
Before trial court.
Yes.
Item number 20.
None appears dismissed. Interim order vacated.
Item 21.
Same order.
Item number 22.
My lord, no, infructuous not pressed.
Okay. Infructuous not pressed. Dismiss is not pressed. Interim order vacated.
Item number 23.
23, my lord, no instruction, my lord.
No instructions dismissed. Interim order vacated.
Item number 24.
And lord, challenging the cognizance order dated 8/1/2013, my lord. In this case, my lord, the petition information.
How come you came to the court after 4 years?
My lord.
You challenging an 8/1/2013 order on 19/1/2017, 4 years after. What is the explanation?
The matter has not been listed.
No. That's not an explanation. Anyway, permitting the petitioner to raise all pleas raised in the present petition at the appropriate stage. The court disposes of the petition.
Lordship, in this case, the name of B.S. Das Associates kindly be deleted.
All right.
Item 25.
Item 25, no instructions.
No instructions dismissed. Interim order vacated.
Item number 26.
None appears dismissed. Interim order vacated.
Item number 27.
None appears dismissed. Interim order vacated.
Item 28.
This matter was filed for quashing of affair on 20th January 17. Well, I don't have any instruction what has happened.
All right.
No, not for disposal. Your lordship may post it to sometime 2 weeks after. So
All right. At the request of Mr. Mishra, list on 9.
because the petitioner is also not aware, only knowing the FIR he came to know. Neither is whether charge sheet has been filed. My landlord can also take instruction. The stage of the FIR, if any, or whether it is a finally dropped, because I know I'm yet to suffer anything in person to the FIR, accepting that FIR was there.
9th December, at the request of Mr. Mishra, 9th.
Item number 29.
My landlord also can take the instruction because I have given some copy to the land council for the vigilance. Oh, sorry.
Item 29.
None appears dismissed. Intermodal.
Item number 30.
30 has become infructuous, my lord.
Infructuous dismissed. Intermodal.
Item number 31.
None appears. Same.
Item number 32.
Item 32 apply for next week, any day, my lord.
Why?
Because some instruction is, because the person happens to be advocate clerk from Kantamaji Bar.
All right. At the request of council, the petitioner list on 9th.
As you know, sir.
Item 33.
May I please, your worship? We find that council is died.
Council, the petitioner stated to have expired. List on 16th December.
Intermodal continue.
Intermodal to continue.
Item 34.
None appears dismissed. Intermodal. Vacated.
Item number 35.
Same order.
Item number 36.
My lord, let it come next week.
Why?
My lord, the petitioner is husband and the opposite party number 2 is wife. And in the meantime, marriage has already been dissolved on mutual consent between the
At the
parties.
request of council, the petitioner would needs time to produce documents. List on 16th December.
Item number 37.
That is on behalf of Mr. Mahapatra Millard, and next week. Matter maybe next week.
At the
Suffering from
request of council, the
cold,
petitioner list on
cold
16th.
fever.
All right.
Item number 38.
Interim order to continue. Millard.
Interim order to continue.
Oblige.
38.
None appears dismissed. Interim order.
Item number 39.
Permitted to withdraw, my lord.
Permitted to withdraw. Dismiss is withdrawn. Interim order vacated.
Specialist item 40.
My lord, 2 weeks time to,
For what, sir?
to last order to obtain instruction to call CD.
His diary is there.
But to
What's the reason? Why do you want an adjournment?
my lord, 2 weeks time to my Mr. Tripathi to argue this matter and have this matter 2 weeks time.
No, where is he?
My lord,
Where is Mr. Tripathi, sir?
my lord, out of my lord in Delhi.
No. He can't just go to Delhi, sir.
Next week, my lord. Have this matter next week.
No, why? Why? What is there in the matter?
Well,
You can raise all these pleas, sir, permitting the petitioner to raise all the pleas reached in the appropriate stage. The petition is disposed of, the interim order is vacated. Just put down his name.
interim order continue, my lord.
Yes.
Item number 41.
Excuse me, boss. Because I'm unwell, boss, I am joining virtually, boss.
Yes.
Oblige.
41.
Yes, 41 to 90.
No, you are for the petitioner or for the
No,
respondent?
he
I am for the
will
respondent.
appear beyond 41, he will appear for.
Oh, after 41. Achha.
Item 41.
None appears for the petitioner dismissed.
Item number 42.
None appears dismissed.
Item number 43.
None appears dismissed.
Item number 44.
Permit to take all the points at the
All
time.
right. Permitting the petitioner to raise all issues. Right.
Item 45.
Yes, my lord. Am I
None
audible,
appears for the
my lord?
petitioner. You're there?
Am I audible, my lord? Item 45.
Yes.
I have filed a short note, 3-pager note with citations in support of my case. I will pray your lordship may kindly have a glance to it, my lord.
Yes.
I am seeking quashment on the ground that the principal accused has already been acquitted by full-fledged trial. I am supported with several judgments of this honorable court and honorable apex court. I have given the, my lord, given the entire list, my lord, in my note. And I will draw your lordship's attention, my lord, to the page 36. And I have also given a translated copy of the FIR, my lord, along with my note.
What is the role attributed to you?
I was standing thereby and I was accompanying the principal accused who shot the gun shot, my lord. And the person who has fired was acquitted.
Mr. Katke, are you aware of this?
Plus, he has not faced a trial. Plus, what judgment my lord is citing? Of course, I don't know.
No, but he says they were acquitted. The co-accused was acquitted, he says. By judgment dated 29 January 2016. He has in fact put it in the note.
No, sir, I don't have the note.
So you take instructions, the counsel, the petitioner contains that the co-accused Sheikh Asif Ali has been acquitted by the CJM Jagatsinghpur by a judgment dated 29 January 2016. So accordingly, it is prayed that the petitioner being the co-accused should not be made to face trial. Mr. Katke seeks time for instructions. The list on 9th December. Interim order to continue.
My note may be kept in the record.
Yes, yes.
A copy may be sought not be lost.
I'm sorry. I lost our one.
Item number 46.
None appears dismissed. Interim order.
Item number 47.
47, my lord. Mr. Konda, who has filed this case, he has joined in government panel. Today I have been interested in chief list. I pray 3 weeks after. 3 weeks after.
At the request of counsel, the petitioner list on 6 January.
Interim order to continue.
Interim order to continue.
Okay.
Item 48.
Permitted to withdraw with the liberty to file appropriate application.
All right. Not application, you go before permitting the petitioner to raise in the present petition, the appropriate stage. Petition is disposed of.
Item 49.
None appears dismissed.
For orders, item number 50.
50 I have appeared for opposite party. The place of
petitioner.
I am for the petitioner, my lords.
Yes.
Your lordship may seek 9/9/2022 order. 9/9/2022. And
Yes,
accordingly, I had served a copy on my learned friend.
He's there. He's there. Yes.
There.
What are you saying?
I pray that instruction I have to obtain whether that amount.
Counsel for the artist needs time for instructions. 3rd January.
In the meantime, I have filed a memo and a death certificate wherein petition number 2 is already, she is already dead.
All right. It is stated that petition number 2 has expired. Where he filed an IA.
No, I have filed a memo. My associate must be there in the court.
So on the way, I will file it today.
All right. List January.
Obliged.
Grateful.
Item 51.
None appears dismissed.
May I please, your lordship?
On behalf of HL Mahapatra, item 51, pass over, my lord.
Pass over. All right. Pass over.
51 passed. Item 52.
None appears dismissed.
Item number 53.
May I please, your lordship? Notice shows, my lord, the requisite has been filed, my lord.
Not filed, sir. That's the noting.
But I have filed, my lord.
When?
So after order, my lord, notice it has been filed. So
You can't get into that, sir.
direction is given for.
What's the matter about LS?
Matter, my lord, cognizance has been taken under section 138 NI Act, my lord. But here, my lord, party company has not added as party, my lord.
I see.
Lordship, as in the view of the decision of the lordship, criminal appeal number 838 of 2008, my lord. That
Sundry Advisory Limited.
my lord, that
this is covered, sir.
Covered matter.
Mr. Katke, without the company being made a party, the only directors cannot be made a party.
The NI Act plus.
That's what 141. You say the challenge in the present petition is to the order dated 7th April 2014 passed by the SDJM Baripada in ICC number 283/2013, taking cognizance against the petitioner for the offence under section 138 of the Negotiable Instruments Act 1882. Paragraph admittedly the complaint has been filed on the basis of the petitioner having been the director, is it? Of Sunray Advisory Limited, which in whose name the check was issued. Full stop. Further, it is an admitted position that the said company has not been arrayed as an accused in the complaint. Paragraph, it is settled position in law as explained in Godfather Travels versus Anita Huda. Take the whole citation. That for the purpose of the offense under section 138 NI Act, without the company which issued the check being made being arrayed accused, it is not possible for the complainant to proceed only against the directors. Stop. On that short ground, the impugned order dated 7th April 2014 is hereby set aside. The petition is allowed, no orders is to cause.
Item number 54.
Obligement.
Item number 54.
None appears dismissed.
Item number 55.
And for the petition through BC, my lords.
Yes.
In this case, my lords, the petitioner has challenged the order of cognizance. Your lordship can see the complaint petition para 2, that is at page 32. Here he said that he purchased the land and in possession of the same, but as page 40 and 41 under section 32. At page 32, my lord, there is a proceeding under section 23A of Poiler Act, and at page 40, there is an order of delivery positions, and at page 41, the position
has the opposite party been served, sir?
Yes, yes, my lord's notice, no, notice has been, but he has not received as it appears the notice.
No,
The office
notice served.
Notice, my lords, I have filed the requisites, but he claimed he doesn't claim. That means he refused, my lords. Your lordship can see the office note, my lords.
Undelivered letter returned from the address of the opposite party.
Notice may go, my lords.
Since none is appearing for the, what is the matter about, sir?
Matter is against the cognizance, my lords. He has approached, he has filed the complaint with the suppression of the material facts. My lords, he claims that he is in possession of the lands. He purchased the land in the lands, but that is he purchased in the year on purchase on 19/4/1965. He claims, but in 2/7/2016, my lords, in a proceeding under section 23. The delivery position of the lands is given to this accused, my lords, by the Tahsildar. So once due process of law, the land has been given to this petitioner. This complainant cannot claim that he is in possession of the land.
You say fresh notice to the respondent returnable before the roster bench on 6th February.
Item number 56.
Here the defect has been removed on 26/2/2021. I filed the lead copy, typed copy. And there is another matter, madam, CRLMC 3740/2017, arising out of the same model.
When is that coming up?
That will be called along with the because.
Okay, list along with 3740 of 2016.
2017.
2017
CRLMC.
before the roster bench. On
Because after I appeared on 18, it is not.
6th February. It will come before the roster bench on 6th February. Sir.
With this present one.
Yeah.
Item 57.
May please lordship. On behalf of Mr. Bose, my lord, we are challenging for the final report of the police, my lord.
You are challenging what?
Final report.
Okay.
Final report has been
Give
accepted.
liberty for the file the protest petition.
He can file a
Liberty for?
complaint.
File protest petition.
All right. Consider the petitioner seeks leave to withdraw the present application with liberty to file a protest application.
Yes, my lord.
Protest petition.
Yes.
How it is a complaint,
This is
lord.
withdrawn with-
He has received the notice, but he has not before to file a protest petition. That is the reason why final report has been accepted. We can file a complaint.
So you can't file it now, sir. Since a charge has already been framed.
No, charge has not been framed. Final report has been accepted. Your also can peruse internal page.
You say with the final report having been accepted, it's too late in the day for the petitioner to now seek permission to file a protest petition. So consequently, the court is not inclined to interfere. The petition is dismissed.
Item number 58.
May I please your lordship, for quashment of FIR, alleged offences are under section 341, 323, 294 and.
Permit you take all the pleas, sir. Permitting the petitioner to urge all the pleas at the appropriate stage in the trial court. Petition is disposed of.
Lordship,
Right.
Case and counter case, there is nothing in.
It's all right.
Item 59.
The memo is taken and record, dismisses, withdraw. No, dismisses, no instructions. Interim order.
Item number 60.
None appears dismissed.
Item number 61.
Same order.
62.
Same order.
Item number 63.
I am withdrawing it with the liberty to challenge the after charge attempt.
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to raise all the pleas raised at the present petition at the appropriate stage.
Item number 64.
None appears dismissed. Interim order vacated.
Item number 65.
None appears dismissed. Interim order vacated.
Item 66.
Infectious, my lord. Infectious.
Infractuous is dismissed.
Item number 67.
May I lordship please? 67 last time and instruction. His 9 year.
I have passed on. That is the court passed on the instruction. It is also a fake one.
Oh,
My lord, very serious condition. He is in 9 year suffering rheumatoid heart disease, my lord.
just see, documents are fake, so if we start 340 against the your client, he'll be in deep trouble.
My lord.
Second time is producing fake documents in the court. This is the second time, not the first time.
No, I don't know what is the. Sorry, my lord.
It's second time. Earlier also same thing happened, then the council withdrew the application. The second time this is happening. You better advise this person.
My lord, withdraw this. No, withdraw this.
This IAS council petitioner seeks leave to withdraw this. He changed counsel last time. That's how you came in. And again he's done the same thing.
9 year suffering very serious condition.
It's what to do? You can't submit fake certificates.
Sorry, my lord.
It's all right. The IAS disposed of. Main bail application, when is it? In due course. All right.
Item 68.
May I please, your lordship? My lord, last occasion, your lordship directed, my lord, both the parties, my lord, to come to settle the matter. My lord, both of us, my lord, discuss about the matter. Your lordship may direct, my lord, both the party appear for the mediation, my lord.
All right. Good. Both parties are all right. Both parties are willing to explore the possibility of settlement through mediation. They'll appear in the mediation center at 3:30 p.m. on 1st December. 1st December.
My lord, may I pray, my lord, my client is residing at Rajasthan.
8th December.
My lord.
8th December. The mediation report will be placed before the court on the next date. List before the roster bench on 4th January.
My lord, interim order continue.
Interim order to continue.
Item number 69.
I will please your lordship.
Yes.
I'm on virtual mode.
Yes.
But the cognizance taken by the learned SDGM.
Yes.
Under section 384, 186, read with my lord 31 XBI of SC/ST Act.
Yes.
The case, the affair was lost after 8 months. And the second submission for lordship would be that the complainant is a grammar key and I was IAIC. The allegation was made that I have said something like Pada and other things which was supposed not to be said in terms of the section 3 of the SC/ST Act. And I demanded some money. No materials available on record. Lordship, can be turned to cognizance first. My first submission.
One minute. Mr. Mishra, you're appearing in this?
I'm appearing for the petitioner.
No. Sorry. There's also an AP Mishra for the opposite party number 2. Mr. Ashish Mishra, are you appearing this?
My lords, I'm in the next item.
Next item. So we'll have to, because without the complainant, we can't proceed matter, Mr. Kali Prasanna Mishra. None is appearing today on behalf of opposite party number 2, although one Mr. AP Mishra has entered appearance. In the interest of justice, list before the roster bench on 9 January, interim order to continue. All right.
Item number 70.
All right.
Item number 70, may I please your lordship?
Yes.
My lords, here, firstly, I would like to draw your lordship's attention to section 195 CRPC, my lords, which talks about prosecution for contempt of lawful authority of public servants for offences against public justice and for offences relating to documents given in evidence. My lords may kindly refer to the first subclause, which says no court shall take cognizance of any offence punishable under section 172 to 188, both inclusive of the IPC 1860, or of any abetment of any attempt to commit such offence. I may be pardoned, my lords.
1 minute. I'm just seeing this service.
My lords.
Notice back a signature of one Lata.
My lords.
All right. Yes.
My lords. My lords finds section 195.
Yes.
My lord, section 195 clause 1 says that any offence punishable under section 172 to 188 of IPC shall only be instituted and taken cognizance of on the complaint in writing of the public servant concerned or of some other public servant to whom he is administratively subordinate of. My lords gets it? My lords, may kindly now see annexure 1 at page 11, my lords.
Yes.
My lords may see the entries at column 6, 7, 8, 9, 10. My lords, all of these entries are relating to offences under section 1, starting from section 175 to section 188, which 195 CRPC clearly mandates that there should be an administrative order which sanctions such cognizance, my lords. My lord, secondly, I will apprise your lordship of the allegations against me in this particular case, my lords. My lords, here the allegation is that I was appointed as an executive engineer in the Paradip Port
No,
Trust.
but where has the magistrate taken cognizance yet?
My lords, but this is a 1cc case. My lords, this is arising out of a 1cc. The FIR has been registered, arising out of 1cc.
No, but 195(1) only says cognizance won't be taken.
My lords.
Where is cognizance be taken?
My lords, he has challenged the complaint petition.
My lords.
He has challenged the complaint petition.
My lords. I have challenged the complaint case pending against.
No, just see a prayer.
My lords.
Right. So, just a complaint. Why would you ask for the quashing of the case itself?
My lords.
Nothing has happened in it, sir. No order has been passed. Nothing has happened.
This case is prima facie not made out because, my lords, I'll take your.
Then 195 is not the point.
My lords, I'll get.
195 is not the point, sir. Then.
My lords, my lords.
Why should at the stage of FIR? Why should one interfere at the stage of FIR?
My lords, because the allegations against me is that I was appointed as an executive engineer in the Paradip Port Trust in the year 1987, my lords. And the complaint is that I supposedly submitted fake certificates to obtain the said job. My lords, pursuant to that, in the year 2004, a representation was made before the National Commission for Scheduled Castes and Scheduled Tribes, against which investigation was made. The Paradip Port Trust gave all the documents that was presented before it by me at the time of appointment. And my lords, challenging further in the year 2014, a cancellation of caste certificate proceeding was initiated against me by the collector, my lords, which I have challenged by WPC 14139 of 2015, where I have, my lords, given all my bona fides, including my caste certificates and other documents which is required to establish that I am a scheduled caste person. My lords, I have initiated WPC 14139 of 2015 for challenging the order of cancellation of caste certificate, wherein this honorable court has been pleased to stay the order, vide its order dated 24/8/2015. My lords, similarly, in WPC 18376 of 2015, I had challenged the disciplinary proceeding that was initiated against me by my employer, which was also again stayed by this honorable court, vide its order dated 28/10/2015. My lords, now all of these proceedings initiated against me were at the behest of some competitors who were not happy with the promotions that I was getting. And
So this is all at the stage of FIR. All this can't be examined at this stage by the High Court.
My lords,
You can't get into the
my
merits.
lords, kindly appreciate that all of this investigation and the proceedings made up against me has been done in a scrupulous manner only to harass me. My lords, 2004 a complaint was made to the National Commission.
Not even a charge sheet has been filed, sir.
My lords.
Nothing has happened. You come straight away to the court just on an FIR being lodged. You see, the court is not inclined to interfere with the FIR at this stage when even investigations have not commenced. Full stop. Consequently, leaving it to the petitioner to urge all the pleas at the appropriate stage in the proceedings. The petition is disposed of, interim orders vacated.
My lords.
Item number 71.
None appears dismissed.
Item number 72.
No instructions.
Let's say in item 58, compromise had taken place between the parties. That
I don't know, we've gone past 58, sir. Right.
Item number 73.
In this case, I have a FIR. No, kindly see on the basis of the FIR lodged by the ASI that on 23/6/2016 at 1 p.m. He found that some person seeing the police party ran away inside the godown, and suspecting they sought the godown, and on being asked, the said person disclosed that there was a storage of Rajkhaini and they are doing the business. Well, thereafter what happened? Well, thereafter the co-accused already released on bail by the trial court, but so far the procedure is concerned, my submission is, well, I have got the registered from the Celtas department to deal with the matter. But kindly see Annex 2. Annex 2 kindly see. And 2 series kindly see. It was certificate given by the registration certificate by the Celtas department, page 16 kindly see.
16.
Yes, my lord. With reference to your application of registration on section 5(1) of the Orissa entry tax so and so, you are hereby informed that your registration is allowed and registration number so and so assigned to under the rule 5 of the Orissa entry tax. Scheduled goods dealt it. Capitals are notified government pan masala, other khaini, special tobacco, pickles, pan masala, etc. Well, what I am doing, my lord, under the registration issued by the Celtas authority, my lord. Well, without answering to that, my lord, by virtue of your lordship order, kindly see, dated 17/4/2009, it is directed to appear and produce all relevant documents before the authority, before the police station, my lord. I have also entered appearance on 3/5/18 and produced all documents, but till date they have not finalized my matters. Pending till date, I have requested several times, but they have not yet finalized, my lord. Well, my submission, when I have got a registered certificate to deal the matters, well, how can it say that it is contraband, my lord? Also, a report was called for by this honorable court regarding the examination of tobacco. It is also in my favor. There are no contraband articles, my lord. So my submission is why I'm always harassing, my lord. I'm always harassed. So kindly 17/4/2009 order, my lord. I have appeared and produced all my documents, but they have not considered till date. 17/4/2019 order, kindly see. It was sure harassment, my lord.
Yes, Mr. Katkia.
Try to direction. I have filed affidavit that respect also.
Suppose detailed instruction is required.
Right. Sorry?
Instruction is required in this case.
No, you want time? All right. Mr. Katkia seeks time for instructions. List before the roster bench on 4th January, interim order to continue.
Miller. Item 74.
None appears dismissed. Interim order vacated.
Item number 75.
Order of cognizance challenge on the ground that the present petition stands surety for the one of the accused, Mohammed Safiq, but the police submitted a charge sheet against the bailer, my lord, wrongly, and cognizance was taken.
Yes, Mr. Katkia, what about this? He says cognizance taken against the bailer.
The accused number 4 cognizance order, page 11. My age is 65 years. Well, the age of that accused person, name stand in mind.
Let me take instruction in this case, Milos. Why cognizance hasn't taken anything, Milos?
All right, Mr. Katkia, 6 time instructions, interim order to continue list before the roster bench on 9th January.
Item number 76.
Item number 76, my lord, permitted to withdraw with liberty to file a discharge petition in the learned lower.
All right, counsel petitioner seeks leave to withdraw the present petition with liberty to file a discharge application before the trial court.
My lord, another small part, that similar item was item 10.
All right, same order in 10.
My lord.
All right.
Item number 77.
May I please, Raj? Lord, here I am challenging the criminal proceeding against me around that the principal accused as well as all other accused persons have been acquitted after facing a trial. And the allegation which runs through all the accused persons that has been disbelieved by the criminal court, my lord. In this regard, my lord, may I...
Mr. Katkia, where is the judgment acquitting them?
My lord, that's it.
7/7/2015.
Page 20, my lord. Well, before that, may I draw your lordship's kind attention to the allegations? Page 16, my lord.
No, 1 minute. Mr. Katkia, are you ready in the matter?
Yes, I am not. No, of course, I am not agree with the submission of advanced by my learned friend, because he has not faced the trial and he has to be acquitted because other accused persons have acquitted. So that has to be verified, because another matter also you will not.
Yeah, correct. One of the grounds on which quashing is sought is that the co-accused have been acquitted by a judgment date 7 July 2015.
My lord.
Bracket annexure 3. Bracket. Mr. Katkia, 6 times instructions. Interim order to. No, there is no interim order.
Yes,
yeah,
Lord.
interim order to continue. List on 16 January before the roster bench.
Obliged.
Item number 78.
None appears dismissed.
Item number 79.
79, may I please? In that case, when the present petition is the husband, my lordship, he has married to the present opposition number 2, that the marriage has been due to love marriage, that he has alleged that the in-laws members has committed some assaulted the opposition number 2. So in the meanwhile, that the compromise has been made by between the present petitioner and the opposition number 2.
Where is that compromise petition?
Compromise petition is annexure 3.
This has been verified, Mr. Katkia. It's in the form of an affidavit. The compromise petition between the petitioner on the one hand and
498
is a 498 case against
and respondent 2 on the other hand.
Final form has been submitted.
Has been enclosed as annexure 3. Full stop. Despite notice, no counterfeit has been filed. The above position is also not disputed. That view of the matter. GR case number 1858 of 2015 arising out of Remuna PS case number 10 of 2015 pending the final SDJ in Baleshwar. And all proceedings and orders consequent thereto are hereby quashed.
Item number 80.
80, may I please, your lordship, my lord. My lord, there is a delay of 20 days for filing of the complaint petition, my lords.
All right, that delay is condoned. Yes.
No, my lords. Without condoning the delay, my lords, they have taken cognizance, my lords.
Who's for the complainant?
My lord, I am the complainant. I am on behalf of the opposite party. Mine. Will also claim the annexure. Will also the moment cognizance order dated 8/10/2015 at page.
Yes.
11 minor. Rightly, Master has taken cognizance.
No, without considering delay.
Yes, my lord.
No, my lord. In time, my lord, I have filed the
Demand notice was received on 22/6/2015, my lords, and complaint petition was filed on 26th August 2015. 65 days, out of which 20 days is delay, my lords. Deducting 45 days.
The lordship for a moment, page 8. That the accused has a grocery business shop at Babaji Tota Street, Barampur, approached complainant for supply of biscuits of various brands for shop of accused, and as per the order of accused complaint, supplied the items with bill. Against the bill amount, accused is issued a check of ₹2 lakh bearing check number so and so.
of Corporation Bank, Giri Road, Barampur, Ganjam, and he requested complaint to submit the said check at the bank on 25/2015. As per request, complainant submitted the said check with his banker, State Bank of India, Hindlikatu, District, Ganjam. Thereafter, my lord, lordship for E. That finally the complaint.
No, you have to read the order. Where has he dealt with the limitation in the order? Not your petition, sir. The magistrate has to apply his mind and find out if it's time barred or not. Where has he done that?
Your lordship, for a moment, at page 11. The case record is put up today for hearing on limitation. Law and counsel for the complaint is present, filed Hajira. The court fee as per the amendment is paid. Hard peruse the complaint petition, initial statement of the complaint filed by the complaint in shape of affidavit, and the original documents, white check number so and so, drawn on Corporation Bank, Barampur branch. The division or memos, office of the pleader notice, postal receipt, delivered notice, etc., submitted by the complainant. As the offence under section 138 NI Act is based on documentary.
Where is that limitation considered, sir? There's no consideration of limitation at all. Let it go back. You say one of the grounds on which the impugned order dated 8/10/2015 of the learned JMFC, SDJM, sorry, SDJM, Bhubaneswar, is it? Ganjam. Barampur. In 1CC 431 of 2015, taking cognizance of the offence under section 138 NI Act against the petitioner is that the aspect of limitation was not examined by the said SDJM before passing the order taking cognizance. Paragraph, having heard learned counsel for the parties, the court is review that indeed the learned SDJM failed to examine if the complaint itself was time barred. Yes. This is particularly in the context of the contention of the petitioner that it is barred by 20 days.
Yes, ma'am.
It's delayed by 20 days. The contention which is opposed by counsel of the petitioner, counsel for the complainant. Nevertheless, since this was an important aspect to be examined, court sets aside the impugned order dated 8/10/2015 and remands the matter to the file of the SDJM Berampur for the case 1CC number 431 of 2015 to be proceeded with from the initial stage. In accordance with law, the SDJM will first examine the aspect of limitation and then proceed in accordance. For the above purpose, 1CC number 431 of 2015 will be listed before the SDJM Barampur for directions on 19th December 2022. A copy of this order be sent forthwith to the concerned court.
Published. Item number 81.
None appears dismissed.
Item number 82.
None appears.
Item number 83.
May your lordship, I may be allowed to submit on behalf of Mr. Shatrughan Sain, the conducting counsel who has expired, your lordship.
Who has expired, sir?
Mr. Shatrughan Sain.
You have to take a no objection from the petitioner. Have you done that?
No,
you
my
have to get a fresh wakalat, sorry. Fresh wakalat.
My lord, I will take instruction. Your lordship.
What's your name, sir?
My name is Parsuram Das.
Mr. So-and-so appears on behalf of the petitioner and states that he'll be filing his wakalatnama within 2 weeks. List before the roster bench on 6th February.
My lord, interim order.
Interim order to continue.
Item number 84.
Challenges here with under annex of 1, FIR lordship dated 23/9/2015. In the meantime, 7 years have been passed. Lordship, whether charge sheet has been filed or not, I will take instruction.
So it must have become infructuous, sir, by now. This is 85, no?
84.
84.
84.
84.
Page 11 under annex 1. Whether I have no instruction, lordship, till yet.
Then
In the meantime, 7 years have been, I
yes,
take
no,
instruction. 2 weeks time, I will take instruction. Whether charge sheet or what is the stage on?
At the request of counsel, the petitioner who needs time for instructions, list before the roster bench on 10th January. Interim order to continue. Obliged.
Item number 85.
My lord, the informant has filed an affidavit that they have reached and compromised and.
All right, counsel, the petitioner states that in view of the subsequent developments, nothing survives in the present petition. It's disposed of as such. All right.
Item number 86.
Permitted to withdraw as the matter has become.
Dismisses withdrawn interim order. All right.
Item 87.
My lord, the daughter has claimed maintenance from her father, but on the ground of her majority, attaining the age of majority, the learned court has dismissed the petition. That is the annexure 3, running page 16. But there is judgments of the court that the daughter is unable to maintain herself. She is not married. Then unmarried daughter is entitled for maintenance from her father.
How is this order challengeable like this? Isn't the revision maintainable against the impugned order? What is the order challenge, sir? I'm not able to understand. What is the order
Challenge annexure 3, my lord.
What is that order?
That order was that the application for enhancement of maintenance was
Major daughter is not entitled to maintenance from parents, correct?
was dismissed on the ground that the daughter become major. But my lord, there is decision of this honorable court that the unmarried daughter is entitled for maintenance.
No, this order, why are you challenging the 482? A revision is maintainable against that order.
Yes, my lord, the liberty will be given to.
What is the age of the daughter now, sir? Must be already 25 years old.
Yes,
Where's the question of parents now giving maintenance to a 25-year-old daughter, sir?
Permitted to withdraw.
Counsel petitioner seeks leave to withdraw the present petition. Dismisses withdrawn. All right.
Item number 88.
May I please, yours. In this case, my lord, the petitioner challenged the order of cognizance, my lord, taken by the SCGM Sambalpur, my lord. There are two grounds, my lord. Though the cognizance taken under Section 3 SCST Act, my lord, the SDGM is not competent to take cognizance of the SCST Act. First ground. Second ground, my lord, the petition number 2, 3, and 4 are the SC and ST community. So the SCST Act not applicable to them, my lord.
I'm applying for opposite petition 2.
How is the SDGM, how is he competent to take cognizance? SCST Act offense.
Even if first case, final report submitted. Case fake, false case, my lord. Thereafter protest petition filed and
You see, the challenge the present petition is to an order dated 12/8/2016, passed by the SDGM Sambalpur and GR case number 761 of 2016, arising out of Dama PS case number 30 of 2016, taking cognizance against the petitioners for the offence under
341, 294, 5034, 3 SCST Act.
The connection is not complete, I think. Under section 341, 294, 506, read with 34 IPC and 3(10) SCST POA Act. Full stop. Paragraph. This court has heard the submission of counsel of the parties. Paragraph. Apart from the fact that petitioners 2, 3, and 4 themselves belonging to the SC community, and therefore the SCST POA Act is not applicable to them, it is obvious that the SDGM could not have taken cognizance of the offence under that act, as he was not authorized to do so. Full stop. What happens to the other offences taking cognizance?
Other offences will remain as it is.
All right. Consequently, the impugned order, to the extent it takes cognizance of the offence under section 3(10) SCST POA Act against the petitioners, is the petition is disposed of the above. The order be sent to the concerned court forthwith.
89,
None appears dismissed.
item number 90,
I'm on PC, madam, may I plead, your lordship.
Yes.
This is a case, my lord, where the complainant, who is a lady, after marriage, she was tortured, and even the matter went to the extent where the brother-in-law attempted to commit rape. So affair was lost. Affair was lost, my lord. Affair was lost against 15 accused persons. And the cognizance was taken against 4 accused persons, my lord. And so for the rest is concerned, she filed a protest petition, my lord. And the magistrate straightway dismissed the petition, saying that once I have taken cognizance, I cannot take cognizance against the others. So, my lord, while the protest petition has to be filed, the procedure has to be followed, and he must be given an opportunity. Lords may kindly see the impugned order, last page, my lord, page 73. No notice, no information. In view of the facts and circumstances stated above, as after hearing the learned counsel for the complainant as well as the learned APP, it is opposite to say that one question on the point of law. Point of law raising in the mind of this court that whether this court has a jurisdiction to take the offense against the accused persons as mentioned.
I think this is settled, that judgment of mine, that even those who are not charge sheeted, they can take cognizance, right?
Yes, my lord. So here, my lord, this order is passed against the spirit of your judgment. Your lords may kindly let me complete, my lord. Now it is well settled that the magistrate has ample power to disagree with the submissions charge sheet by the IO against the persons who have been charge sheeted, and the magistrate can even at the time of taking cognizance of the offense and all the accused persons who have not been charge sheeted by the IO. But in the present case, this court, then my lord, up to this man, your lordship, it's covered by your lordship judgment.
Correct.
But thereafter, my lord, the case court has already been taken cognizance, GR case number so and so against the accused persons who have been charge sheeted by the IO. As the law is well settled, that while taking cognizance of magistrate is required to take cognizance against the offense and not against the offenders. So this court, after perusal of the available matter in the case record, found that there is a prima facie materials under section 498, 376, 506, 406 by 34 IPC, read with section 4 of the DP Act, to cognizance for the aforesaid sections of law, and thereafter issued summons to the accused persons to their appearance before the court as prior to the submission of charge sheet. They were released on bail. So in my considered view, as on the date of taking cognizance, this court has not added any sections of law or any other accused persons against whom the IO has not charge sheeted. So in my considered view, if the present complaint case be entertained and be proceeded further on the self-same matter relating to the affair lodged by the complaint.
But tell me, this entire 2 to 12 are all younger father-in-law, younger mother-in-law, elder father-in-law, elder mother-in-law. You want to proceed against all of them for these kind of offences? 376.
498, and the girl was driven out. She was again, that boy has again married. She was driven out while she is on the street. Maintenance was, in the meantime, she might.
No. Against husband and in-laws, I can understand. Against all these elder father-in-law, younger father-in-law, and all of that.
They are in-laws, my lord, and there is prima facie case, my lord. I am on a point of law, my lord. Once, my lord, a protest petition is filed, the procedure has to be followed, and he has to take cognizance. He said,
no, it should not become a harassment. It should not become a harassment.
No, harassment, my lord, because the lady, who is a young lady, immediately after the marriage, my lord, she is on the street, my lord.
No, what happened? No, 1 minute. What happened in the other? Cognizance was taken against the husband and in-laws, correct?
Yes, my lord.
What happened in that case?
It was at the stage of commitment, my lord. It was at the stage of commitment. But at this stage, they have filed an application to add, my lord, the present opposite party number 2 to 14. Addition, my lord, they have prayed for addition of the accused. My lord, even the subsequent that is available under section 319 of CRPC.
No. What has happened in that case?
It has not been committed, my lord.
Why? There's no stay.
No stay.
So why was that? Why did that case not proceed? There's no stay of that case proceeding. Mr. Katke, what's your position?
That is covered by your lordship judgment.
I know.
Judgment of Dharampal.
No. But why did the case against the others did not? He says it did not proceed.
I have to take instruction, my lord.
That I have to take.
Husband is dead. To my instruction, husband is dead, my lord, in the last corona. 1 week.
Husband has died.
I have to take.
Why don't you find out? Counsel appearing for opposite parties 2 to 14 states that to the best of his knowledge, the husband of the present petitioner expired during the Corona-19 pandemic. He is also not clear whether the trial has proceeded against the other accused against whom cognizance was taken by the learned
SDJM Sadar Katak.
Sadar Katak. Mr. Katke also needs time for instructions. List before the roster bench on 9th January. All right.
I pay for a free copy, Mulas. I humbly pay for a free copy.
Sorry?
Free copy of the order.
A copy of the today's order is issued urgently. All right.
Specialist pastor matter item number 16. Item 16.
May I please your lordship, on behalf of Mr. Ragda, I may be permitted to place the.
Yes.
My lord, this is the case under section 13(1)(d) of PC Act and section 120B of IPC and 467, 468, 471 and 34 of IPC. My lord, in this case, my lord, Odisha Rural Housing Development Corporation had sanctioned a loan of rupees 1 crore to Shankarji Mahapatra. My lord, and meanwhile, my lord, it is executed by petitioner the Prasanna Kumar Hota IS, CMT and ORHCD on 31/12/1997. My lord. And my lord, he has also given a land zone of rupees 4 crore 70, including the 7 lakhs towards the expenditure on this basis as the mortgage.
There is no stay granted by this court. The trial must have proceeded. What happened?
My lord, trial is going on.
It must be going on then. Why should we interfere at this stage? You say there was no stay granted by this court of the trial court proceedings, which has been in progress for over 6 years now. At this stage, the court is not inclined to interfere.
Well,
permitting the petitioner to raise all the pleas at the appropriate stage in the trial court, the petition is disposed of.
All right. Item number 31.
My lord, on behalf of Mr. H.N. Mahapatra, my lord, item 51. My lord, matter was already settled, my lord. My lord, kindly see Annex 3, page number 13, my lord. The compromise between both party, my lord.
Somebody to verify this. Mr. Katke, this compromise, it's only on a. Mr. Katke seeks time to verify Annex 3, which is stated to be the compromise deed, at his request list on 16th January 23 for the roster bench.
Obliged.
For Namaskar. Sir.
Supplementary list for admission item number 1.
This is a case for review. We have given a short note for convenience. We have listed out 4 apparent errors in that order. The main point here is that the petitioner was not heard, and the violation of natural justice is something which the court somehow didn't take note of. It was dismissed at the threshold stage. No counter affidavit was also called. So, so far as I believe that so far as review is concerned, we may have a good case. And the objection now that they are raising regarding 50 years and all, that is something which can be thrashed out in the main writ petition. If they file their counter, what relief we can get can be molded there. If my lords would see the note, those 4 also have explained that these are the 4 patent errors.
Supply out the copy of the note.
Note. Give a copy. These are short submissions. Last date we had given. I think Mr. Mahanti was there.
You have to file an affidavit. Has that happened?
Yes. Now the affidavit, they are saying that this area is not given to anybody. So in view of that, all these issues, let it be thrashed out in the writ petition. They will have their say.
No, but what's that the area is not let out to anybody.
In view of this paragraph 6 and 7, what they have filed in the affidavit,
my lords,
ultimately in your writ petition, suppose it is, let us say that review petition is allowed,
my lords,
ultimately it is taken up for fresh hearing.
My lords.
What relief you will get, because in paragraph number 7 of the affidavit,
my lords,
they have specifically stated that
it will be now put to auction again.
Yes. So in view of this para 7, in fact, what falls from your lordship, I had internally queried from my instructing counsels. We have a rejoin ready for that paragraph, wherein we say that
they say that for manganese and graphite ore,
my lords,
this extension cannot be granted because of that amendment from in that act.
From the Act. Now, so far as this is concerned, there are 2 submissions. One is on the date relevant. We could, if we would have got an extension, then at least we would have got a further extension. We would have been entitled to 3rd. And this 50-year period that they are calculating, in fact, that should be from 74. So at least till 24, the list is alive. It's not that it's an absolutely dead list, which we are. If my lords want, we have the rejoinder ready also. And a note for this specific note for this
let's take the rejoinder. Take the rejoinder.
Mayor, only just in fact, the initial lease was executed on 24/1971. That is the case of the 71.
And so subsequently, one more mineral was added by way of a supplementary deed in 74.
That does not extend the period of lease.
Yeah,
only mineral
lease will not get added.
Now, my lords may kindly see a question that they are raising of 50 years.
Yes.
That we have addressed in this new note in change in law, ground number B. I'm also have instructed them to give this to Honorable Justice Sahu.
Right. Ground.
So ground B, change in law. If I may place
in your note.
Yes. Today we are giving. Today, my lord.
Oh.
Today you have given us the rejoinder of the petitioner to the affidavit. That you are pressing, Mr. Misra?
My lords, we have prepared a note for this 50-year period. Why this will not apply in this case?
That there with us.
No, I have just got this rejoinder of the petitioner. That's all today.
So may I submit, my lords? We circulate this note. Let a short date be given regarding this 50-year period. We will apprise.
The rejoinder has been filed with the petitioner today in response to the counter affidavit on behalf of the opposite parties, in which it is mentioned that pursuant to the amendments to the MMDR Act, the going for a fresh auction in respect of the mining lease for graphite and manganese. Full stop. Paragraph. Mr. Gautam Mishral and a senior counsel of the petitioner states that he will be supplying a note of arguments, a further note of arguments on this specific aspect No, full stop. It is also pointed out that the 50-year period of the lease dated
It started from 71.
1971.
1971 has already come to an end, and therefore, in any event, no relief can be granted to the petitioner. And then you say Mr. Mishra states that he will be submitting a note specific to the above points.
Yes.
Today with an advance copy to counsel for the state. List on 16th December. Right. Right.
The rejoinder may be taken on record.
Yeah, we've taken it. Namaskar, sir.
Supplementary list for orders, item number 1.
Aye.
These have become item 1.
Yes, none appears dismissed.
Item number 2.
Again, none appears dismissed.
Item number 3. No
Yes.
specific reliefs have been claimed in this IA.
IA.
Only an intimation that they have already disposed of they have already complied with the
Correct. I think this is all just kept pending without realizing that the main matter is over.
Exactly.
Right. 3, nothing, none appears dismissed. 4 also and 5 also.
And 5 also.
Correct.
Item number 6.
This I have filed this CMAPL application.
What's the delay, sir?
Delay is Lordship 292 day delay.
292 days.
Lordship.
Ah.
I have filed on my Bhaklatnama. And today also my name is not reflected in the list.
That's all
Lordship.
right. That's all right. You're there. Delays to be explained, sir. That's all.
Due to the previous conducting counsel,
No.
he has not intimated to the petitioner and
You have to follow up, sir. You have to follow up. There's a
Lordship,
delay of 292 days in filing this
Lordship, may I
CMAPL.
submit one thing?
All right.
Please?
All right.
The earlier order passed on 18/4/2019. In this case, I have quoted in para 3 Lordship that the aforesaid writ application was listed in 18/4/2019, and the same day the Honorable Court has been pleased to pass the following order. Learned Counsel, for the petitioner request for time to remove the defects as pointed out by the office, time is granted till 1/5/2019 to remove the defects. But the previous conducting counsel has not taken any step on that time. And after that, the COVID situation arises.
No. COVID starts in March 2020.
March 20, Lordship.
This happened in May 2019.
Lordship.
2nd May 2009.
But in that period, the petition contacted.
All right. You said the delay of 292 days is not satisfactorily explained. Consequently, the court is not inclined to condone it. As a result, IA number 139 of 2022 is dismissed. Consequently, CMAPL 186 of 2022 is dismissed. All right.
May I request, my lord? 1 to 5 appearance of honorable noted, my lord.
All right.
Otherwise, it will non-appearance will be.
All right. Right. Sir. Thank you.
Next.
What's the main matter about?
There's a file for restoration.
No. What is the main matter about?
The main matter is about a PIL matter.
What is that?
There's a compensation granted by the government for the damage for the agricultural field that has been damaged in the year due to the filing.
But look at your prayer in the main writ petition.
And it's the main writ petition is covered up by the 2 other writ petitions. Those are already filed for restoration. That is 7283 of 2015 and 7285 of 2015.
Those are still pending.
Oh, this is 7284.
Are those two writ petitions pending? Or have they been disposed of?
Disposed of.
They've already been disposed of then.
Covered up.
All right. All right. You say if the reason stated therein, the order is recalled and this writ petition is restored to file. In the main writ petition, you say the petitioner's representation at Annexure 4 will be examined by the collector cum district magistrate. This is also Jajpur, is it? Jajpur, and after giving a hearing to the petitioner and examining the records, the collector shall pass a reasoned order within a period of 4 months. And in any event later than 1st March 2023. The court clarifies it is not expressed any in the matter. The writ petition is disposed of. All right.
May I please, your lordship?
Item number 2.
May I please, your lordship, I filed this IA for recall of the order, your lordship. Your lordship, I bow down before your lordship may pass any order.
Okay. What's the main writ petition about?
It was regarding the loan taken from the OSFC and for the respondent, your lordship.
Oh, yeah, for the respondent.
Yes, your lordship.
Your lordship directed them to refund certain amount.
All right, all right. All right.
I bow down before your lordship.
All right. No grounds are made out for recall of the order. Dated 7/5/2022. The application is dismissed. Thank you. Thank you.
Item number 3.
Paragraph 2 of the order, my lord.
Yes.
Plot number 4, in place of 458, it has been mentioned 498.
458, is it?
Yes. Yes.
All right. The application, for the reason stated, the application is allowed. The plot number in para 2 of the order dated 24/2021 be read as plot number 498.
It has been mentioned 498 instead
458.
of 458.
All right. It will be read as 458. All right.
Oblige.
Item number 4.
Please, your lordship, my lord. My lord,
interim bail
has been convicted, my lord, under section 302 and allied offences, my lord.
Copy has not
Lord, my lord, I have filed, my lord, an application for interim bail on the ground of
As copy has not been served.
medical treatment of her wife.
my lord.
You have to serve an advance copy, sir. Just put down IA 728 of 2022. Again, a copy of this application be served on this.
Another copy may be served on me, my lord. I am happy for informant, my lord.
Oh, as well as Mr. Ragada, who appears for the complainant. Informant. List on 2nd December, sir.
For second item is concerned, my lord. Sub-item, second sub-item, my lord. That may be delisted.
Delisted, is it? All right. Second sub-item need not be shown, huh? The next date. Right. Right, sir.
For orders item number 1.
May I please, my lord, your lordship. The petitioner are the students of pharmacy college, my lord. Homeopathy pharmacy college, my lord. Well, they have due to the non-affiliation of the institution, my lord. The petitioner were not allowed to sit in the examination, but in the similar circumstances on other cases, my lord, your lordship, at the intervention of this honorable court, my lord, course completion certificate was issued in their favor, my lord. Even though those colleges are also not affiliated, my lord. That is why the annexure 2, your lordship will find at page 13. The judgment is squarely covered our cases, my lord. But while passing the impugned order judgment, my lord, the honorable court did not take into consideration that factor, my lord.
No, was it brought to the notice of the court?
Yes, my lord, that was there, my lord.
Well, how do you know that?
Because earlier, my lord, earlier this petitioner was approached before the Honorable Court, my lord. The Honorable Court directed the authority.
Did you show the bench this order dated 9/11/2002?
My lord.
No. Did you actually place this order before the bench? Or you suddenly found it after the review?
No, that is annexed to the writ petition, my lord. That was. And reflect on, my lord. Your lordship, that order also reflects into order judgment, my lord.
No. Where is it annexed? It's not annexed.
It is reflected in the order itself, my lord. The improved judgment, your lordship will find, my lord. And if second paragraph.
Which paragraph it is reflected?
Yes, my lord, that is given, my lord.
No, where is the 9/11/2002 order is not referred to?
No, not referred.
It was not produced before this court.
No, that was.
No. Not either with the writ petition or in the as an annexure. Sorry, sir. No grounds made out for review. The review petition is dismissed. Right.
Item number 2.
Here I have some preliminary objection. There are 468 days delay. This item 2, 4, 5, 6 are similar. Same case out of the common judgment. And this judgment has been upheld by the Supreme Court. They have already implemented part of the judgment.
Oh,
no. And your lordship's order also in the so far as the state appeal, and there is no potential for condemnation of delay.
Oh, I see.
I think it has not been brought to your lordship's notice. And that order you also passed on the basis of your lordship's judgment, this judgment. This bench, with my Lord Justice Panigrahi also.
Yes.
The judgment
Already been
upheld by the Supreme Court. Upheld by the Supreme Court.
No, not upheld.
Yes,
So
no.
that regarding upholding that for that reason the review is filed. And last occasion your lordship specifically on this point asked me to question with regard to
No, but the review petitions have time barred.
Otherwise also time barred.
My lord, after the SLP was dismissed, the process of implementation was taken up, in course of which it was came to the fact that the division bench in the writ appeal, the relief was granted, which was even not prayer. And the issue with regard to eligibility, that was not the subject matter of the writ appeal, nor before the honorable single judge, and it was been held that as they are eligible. Well, that
you have traveled up to Supreme Court has not just your
Babita Satpathy, same. The first one is Babita Satpathy, SLP dismissed.
Yes. That against that.
Once SLP is dismissed, where's the question of entertaining a review?
See, I have relied upon last occasion that Korea distillery decision. Even that your lordships also put me last occasion a question as to whether that eligibility part was taken as a ground before the Honorable Supreme Court in the SLP. And I have examined that.
That's time barred also, sir.
He has not filed any petition for condemnation of delay.
Otherwise also time barred. Even if you have merit, still it is time.
Even after disposal of the appeal.
It is pointed out by Mr. It is pointed out by Mr. Rautril and his senior counsel appearing for the respondents in the review petition, that the present review petitions are themselves delayed by over 400 days.
468 days. 468.
416.
468.
Are delayed by 468 days, and there's not even an application for condemnation of delay. Paragraph, even if there was such an application, the court would not have been inclined to condone the delay in filing the review petition. Paragraph, even otherwise, no grounds have been made out for review of the order of the court. The review petitions are accordingly dismissed both on the grounds of delay and as well as merits.
4, 5, 6 also same.
Right. Same.
4, 5.
And even that SLP number may be reflected in the order so that they cannot.
No, that's all right.
That's all.
The SLP number has been mentioned. But only one thing I pray, let the so far the present appeals against which the review petitions have been filed, your lordship's order, but that may not be treated as a precedent, because the fact still kept up.
That individual case, what you say is right.
Batch. No, I am saying for this batch only.
No.
Because others are filing writ petition saying that
let those be decided. No, let those be decided. Sorry.
One
These contempt petitions, what
one
do
of them petitions been disposed of because they have not complied with partly they have complied with, partly they have not complied.
all right.
No, in
The
view of
contempt petitions are, now that the review petitions have been dismissed, the contempt petitions are disposed of with the direction that
Yes.
there should be a full compliance of the orders in question by the state within a period of 2 months from today. All right.
Item 4, 5 and 6. 2, 4, 5 and 6. All the 4 matters. For admission item number 3.
Yeah.
Lord, I appear for the petitioner in item number 3.
I paid 2 weeks time to file counter, my lord. I'm appealing for the opposite party, my lord.
I want to say something. I would have
Yes.
normally not opposed. Lord,
Yes,
3
yes.
occasions they have taken time to file. We were not heard. Lord, please see. 8th April, 8th July, 9th September.
My lord, as a last chance, your lordship, as a last chance.
What happens is because- and we were admittedly not heard. It's not that Lord, we were heard. What I would urge before your lordship.
Yeah, if they're not heard, it has to go back, sir. If they're not even heard.
As a last chance.
What is there to file a counter if they've not heard? You say the principal ground on which review is sought of the order dated 22nd February 2021 passed with this court in writ petition civil number 6264 of 2021 is that the review petitioner the review petitioners 1 to 5 here were not heard when the order was passed. Full stop. This is factually disputed by any of the respondents. Full stop. On that short ground, the order dated 22/2/2021 in writ petition civil 6264 of 2021 is hereby recalled. And the said writ petition is restored to file of the roster bench, where it will be listed for directions on 2nd January 2023.
May I just say something, Lord?
Yes, please. Yes, please.
Lordships could add without issuing notice and without hearing. So no notice was also.
All right. All right. To whom neither was notice issued nor were they heard. All right. All right.
Obliged,
All right. All right. All right. Yeah. Yeah. Right. Good afternoon, Justice Mahapatra.
Don't file you. May I call?
I don't know whether he's able to.
Like, lordship, I can't see your lordship.
Oh, I see. You can hear me. Okay.
Supplementary list for orders item number 1.
All right.
My lords, filing my objection. My lords, the IN number was not known to me today, so I could not file it.
Okay.
So I'm filing it today, given a copy.
All right. Mr. Pal hands over his objection to the review petition and has handed over a copy to.
It's a recall application, was converted.
Yeah, application for recall. Yeah.
Your lordship last order.
Correct, correct. just put on IA number 2 of 2022, the preliminary objection of Mr. Pal to the present IA is taken on record. A copy has been handed over to Mr. Manti. I think Justice Mahapatra's file will not have it.
My lord, next week.
All right. List on 9th December.
Grateful.
All right.
Item number 2.
Past judgment, I was appearing for the petitioner. Mr. Raut was appearing from the opposite party. But the judgment wrongly, this was typed.
I see.
Not mention my name as a petitioner.
All right.
And all the
You just say the correction we carried out as pointed out.
Man.
The judgment, earlier judgment be downloaded and the corrected judgment be uploaded.
Man.
All right. All right. Sorry, sir.
Bro, you must have received the fees, professional fees.
Mr. Raut will take over my fees.
All right.
Item number 3.
My lord, I have prayed for restoration because I was suffering from
All
corona.
right. For the reason stated therein, the application is allowed. The order is recalled and writ petition civil 8087 of 2012 is restored to the file of the roster bench where it will be listed for directions on 2nd January.
Obliged.
All right.
Item number 4.
May I please, Your Lordship? First of all, I apologize that I am filing the affidavit today. Couldn't file earlier. I have just given a copy to my friend, where Your Lordship wanted that whether this plan can be diverted or not. They have assigned certain reasons, and in fact, I have filed this affidavit bringing to Your Lordship's notice certain documents which will wipe out the very accusation itself because it is totally without following anything. Since I have given the copy just now to my friend, Your Lordship may kindly fix a date, my lord. I am filing.
All right. Mr. Samir Mishra files a further affidavit along with documents today with an advance copy to Learned Counsel appearing for Gale. Full stop. The affidavit is taken on record. 9th December. Sir.
I'm obliged.
9th December.
Item number 5.
But I have also submitted a pen drive today just to indicate the hazard because each and every occasion.
Along with a pen drive, which is
pen drive has been submitted, my lord.
You give him copy.
Yes. I'll send him through mail. I have obliged, man.
Item number 5.
Well, item 5, I've sought for review on the basis of a decision of the government, which is at Annexure 12, which was not within my knowledge, my lords. All similarly placed hotels, my lords, they have been given an extension of time, giving bank guarantees and other things, my lords. Even a hotel which was litigating before your lordships, that is Hotel Cabana, 175, my lords. Again, the same treatment has been meted out to them. This is a decision taken by the government on 22/1/21. In all fairness, the government should have disclosed this before your lordships, and we were not aware of this. Later on, we can find out that this is what has happened to all the other hotels, my lords. So I'm only the only one singled out. I'm only praying that they take a decision considering the decision which is reflected in Annexure 12. They don't deny this also.
And Lord, we have answered this very point raised by our counter affidavit. We have also filed supplementary affidavit.
Mike, I think Justice Mahapatra will not.
I'm sorry. We have filed counter to this argument and we have also filed a supplementary affidavit. This is a case which is not equal to the case which my learned friend is now trying to praise before your lordship. And I have the chart also in my counter affidavit. All these points he should have raised before the appellate authority, not that the review in the review there is less scope under.
No, but what is different in his case, which you find
that I have given in my reply also, which I have filed just day before yesterday.
Where is that?
And the counter affidavit on 16/11/2022, and another counter affidavit was filed by me on 29th June 2022.
16, yes, that's there.
And 16th November, 29th June. There are two affidavits to this review petition.
Category of hotels, we don't come under the category. We also come on. Malos, they say they come under the category of hotels, Malos. We are also a hotel, Malos. They have allotted same policy under the same state. Lordships may see paragraph 3 at running page 3. that in response to the paragraph 6.0 of the rejoinder affidavit filed by the petitioners, it is submitted that the claim of the petitioners regarding discovery of significant and material facts is not true. The hotels which have been cited by the petitioners in respect of which performance bank guarantees have been called for are not similarly circumstanced with that of the petitioners, in as much as these hotels, unlike the petitioners one, are coming under category of hotels. We are also a hotel, and performance bank guarantees have been called for in respect of these hotels, taking into consideration the state tourism policy
mean?
2015.
Why is he not a hotel? He's also having this land only for a hotel.
And it has
in fact, the title itself, the company's name itself is South Pack Hotels.
South Pack Hotels. And my lords,
So no, so far as this point is concerned, this averment in my affidavit is concerned, I will clarify it. Lordship.
Better you file a specific affidavit indicating how it is different than the other units.
Yeah.
Yes, ma'am. Your Lordship.
He said, despite the affidavit dated 16 November 2022, where it is sought to be contended that the others, in whose cases the renewal of lease took place, were single course hotels, whereas the petitioner is not, it appears that in fact the petitioner is also a hotel, as its name itself indicates. Full stop. The land is in fact allotted only for the purposes of a hotel.
Building a hotel.
That is the claim of the petitioner.
No. It is there in the lease deed. It's there in the lease
deed itself.
And it's under the state tourism policy.
Mr. Manthi, Leonard AGA states that on specific to this aspect, he'll file a further affidavit before the next date, 16 December.
Deeply obliged.
All right.
Right.
Deeply obliged.
Right. Namaskar, sir.
Orders item number 1.
In this case, I am the petitioner, my lords. These are disposed of case, my lords.
Right.
Only prayer, my lord. I have filed
Where is his IE?
This is workman or died, my lord. My lord has directed. My lord has directed how about the amount deposited by the management in the code be released to the workman. The workman died. So only I have
in view of the reasons stated in the application, the amount directed to be released by this court to the workman shall now be released
in favor of his
legal representatives whose names have been indicated in para 3.
Anjali Panda wife.
Okay. In favor of Srimati Anjali Panda, the widow of late Sri Manoj Kumar Panda. Upon proper identification, the application is disposed of. Right.
Item number 2.
The typographical error is corrected as pointed out. All right. The application is allowed.
Item number 3.
3 is also same. One is filed by the appellant for the same.
You can put on both these IAs and say the error is pointed out.
Only appellant, in place of appellant, it will be respondent number 1 or 2.
All right. And the corrected order be uploaded. The earlier order be downloaded in correct order.
Item 1.